back for another work session. Up here, we're back on live streaming. Yep, it looks like we're all set and ready to go. Good morning, everyone. This is the meeting of the Joint Standing Committee on the Judiciary. This morning, we have a number of bills that we'll take up in the morning. And then we will do a bunch of work sessions and amendment language reviews starting whenever we finish this morning's work. I did want to let people know what the order of bills is this morning. It's also posted in the chat so that both attendees and panel members can see it. But the order of the bills is 906, 1218, 585, 1568, and then 1626. I also did want to let everybody know that there's been a little bit of miscommunication on my part regarding scheduling the hearing on this this series of bills. And because of that, there's been a couple of different messages about whether the public hearings were on or were not on. We have scheduled the public hearings. We're definitely going to do public hearings on each of these bills. We're grateful that people are interested, and we'll take the testimony of any member of the public who has appeared and who wishes to be heard on the bills. That being said, we also, because each of these bills needs some additional work, that's hard to do this late in the session when our schedule is so jam-packed, we anticipate tabling each one of these bills to allow us to do additional work after the public hearing. And then we actually will schedule each one for another public hearing during the second session, because we do again anticipate that there will be some work on the bills between now and the second session. And so committee members, are there any questions about that before we get started? Not seeing any questions. Okay. And so with that, I just want to check in with my co-chair. He's on the phone, but I think we'll start with committee introductions at this point. And Representative Babbage, we'll start with you.
Thank you very much, Madam Chair. Good morning, everyone. My name is Christopher Babbage. I represent House District number 8, and I live in Kennebunk.
And Representative Reckett?
Yes, my name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
And Representative Moriarty?
Good morning, all. I'm Steve Moriarty, coming to you from an overcast District 45, which is Cumberland and part of Gray.
Representative Sheehan?
Thanks, Madam Chair, and good morning, everyone. I'm Erin Sheehan, and I proudly represent Biddeford's House District 12.
Representative, thank you. Representative Babbage, did you have a question? You're muted.
Thank you. I wasn't going to object to anybody's introduction, Madam Chair. I just wanted to explain when everyone was done that I will be in tax and education a lot today, and I feel bad about missing committee, but I'll be back as much as I possibly can. Thank you.
Thanks, with appreciation. Okay, and I think that we were on Representative Sheehan had just introduced herself. Next, we have Representative Libby.
Morning, coming to you from Augusta. I'm Laurel Libby. I represent District 64, which is part of Auburn and all of Minot.
Representative Poirier.
Thank you, Madam Chair, and good morning, everyone. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Evangelos.
Good morning, everyone. Jeffrey Evangelos, House District 91, and I reside in Friendship.
Representative Newell.
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell, and I serve as a Passamaquoddy Tribal Representative. Thank you.
And my co-chair, Representative Harnett.
Thank you, Madam Chair, and I apologize. That phone call was about today's hearing, so I apologize for not being available. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I live. Thank you very much.
Thank you. And Representative Thorne, I was going on a previous committee list before you joined us, and I'm sorry that I skipped over you. Go ahead and introduce yourself.
No worries. Thank you, Madam Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and Etna up in beautiful Penobscot County.
Thank you. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. I'll be chairing today's public hearings, and I'm very pleased to be with everyone today. And let's see, a little bit of information about the public hearings for both committee members and members of the public. The public hearing is really our opportunity to hear from members of the public and stakeholders who wish to weigh in on the legislation we'll be considering. We will, particularly with regard to the bills this morning, we'll have an opportunity to hear from members of the public and the bill sponsors, and then we'll actually have another opportunity in a public hearing scheduled for the second session. And then we'll have work sessions where we'll be able to kind of express our own opinions and weigh in on how we feel about bills. But the public hearing is really our opportunity to hear from the public. And we do have quite a few people signed up this morning. So we'll have a great opportunity to listen to all of the feedback from members, people all over our state who are interested in this legislation. And with that, we will open the public hearing with a bill from our fellow committee member, Representative Rena Newell. And Representative Newell, welcome to your committee. You can begin whenever you're ready. And this is the public hearing on LD 906.
Thank you, Madam Chair. Good morning, everyone. I just wanted to briefly summarize, give a little background on the bill that I had submitted, an act to provide Passamaquoddy tribal members access to clean drinking water. This was submitted, before the cloture date, and more recently, since it was referred to committee, immediately after it was referred to the committee, I made a request, to the chairs in regards to this LD 906. I just want to give a background of the concerns regarding the water quality here in Sabayak. And this was the purpose of submitting this bill as an open concept bill at the time. If there's been numerous articles and coverage over the last year or so in regards to the water quality here in Sabayak, in particular with the drinking water concerns. And I believe I've been working on this since 2018, probably the fall of 2018. So what I'm going to ask the committee, if that's enough of a summary in regards to the purpose of this bill and the ask for consideration to have it carried over. I want to mention that in the past year, there have been numerous year and a half. I'm trying to summarize this as best as I can. There have been a number of internal water meetings, which then expanded to address the water quality issues, which then expanded out to invitations to our local water district, as well as, to the state and to federal interests, which formulated a larger stakeholders meeting, of which we've had somewhat quarterly, which has allowed us to identify short-term goals and long-term goals to try to remediate the drinking water issue here in Sabayak. It's been a long-standing concern here in Sabayak over the years, often receiving notices to boil water But I think since I've really been paying attention to this, I've noticed, issues regarding discoloration, where it's either brown or it's green. At one point it was black. And then of course the testing. Happy to report though that as far as the testing has been in compliance in recent quarters. So that's, that relieves some of our concern there. And there's been, dialogue around that and encouraging, quality water testing here in Sabayak as well. Getting back to the other issues regarding, the color and the smell. We are in the process of trying to find resolution to address that. I think there's going to be additional conversations that are going to take place, and projected. What the tribe did themselves was try to offer the tribal citizens here in Sabayak an alternate water source. So what we did was we went on our fee land and built off of an existing well, put a manual pump in place, lighting, a structure overhead, which is about 2/10 of a mile from my house. But what we normally do is we travel probably 10 to 15 minutes to access from another well and bring bottled water in. And there was a lot of efforts during the response to COVID of receiving donations of bottled water and getting those distributions out to the households here in Sabayak. Our local short-term water solution of putting in another well, we fell into the winter weather, and we have not since been able to really get that going locally. So that's something that needs to be addressed. That was a short-term goal, in addition to the donations received of bringing bottled water in to the community. I think long-term goals, of course, are still in the works. So I think those are what's going to contribute to the discussions around our water issues. We're projecting to have somewhat of a solution, perhaps, in the fall, in the fourth quarter of 2021, which will be a proposed carbon filtration system. So, Madam Chair, if that's enough of a description to warrant, my request to allow additional time for these discussions to evolve, to find the resources necessary to put forth at least, a seemingly option, or a seemingly good option to address this. Then I would make a request to the chairs as well as the committee to table this issue until the second session.
Thank you very much, Representative Newell, both for the presentation and for the tabling request.
Or a carryover request, Madam Chair, I'm sorry.
No, I think the request at this point is tabling. The carryover decisions will be made in a different context. So for today, on each of these bills, we would just do a tabling motion. And before we move on to the tabling motion, I just want to check in and see if committee members have any questions. Go ahead, Representative Poirier.
Thank you, Madam Chair. And Representative Newell, I just had a couple of questions, if I may. I know the state did have a small public water system grant program that they were offering. Is that something that was applied for by the tribe?
Thank you for the question, Representative Poirier. There's been a number of conversations with the Maine State Drinking Water, EPA, our local water district, Wabanaki Public Health, and the tribe themselves to try to identify those resources necessary to, as I mentioned before, implement, this potential solution. So I hope I answered your question. I think we are seeking out as many resources as possible to support the purchase and the implementation of this carbon filtration system.
So you're exploring the option.
Yes, as one option. Yes.
And may I ask one other question, Madam Chair?
Yes, go ahead.
Thank you. And I know also that the state had offered an alternative groundwater study, but I believe that option was declined. With all of the other options being explored, could you tell me why that was declined if you're looking into all these other options?
I think the last feasibility study that was conducted was in 2010. I think it was expected that there would be another feasibility study conducted again. I'm not sure if that was a redirect, Representative Poirier, on the funding. Perhaps.
This was something, I believe it was just last year that the state had actually offered an alternative groundwater study. And the tribe had declined to have that study done by the state.
Oh, no, there was no, we did not decline. There were plans in place during this discussion since the beginning of 2020, actually since November of 2018. I'm just looking at my timeline here. And the larger stakeholder meeting started occurring, I believe, in January. That study that you're speaking of was in the plan because the last one being conducted in 2010, I believe. So there was a plan in place to conduct that study. However, I think more recently, I'm suspecting that it may have been redirected.
And are you talking about the state study?
Representative Poirier, I'm sorry to interrupt you, but it sounds like these questions may be something since we all meet together in the context of the second public hearing on this bill and also the work session, that these may be, perhaps you could email either myself or Representative Newell a list of these kind of really technical questions since we are going to do a second public hearing on this.
Okay, sure.
Thank you. That's really helpful. Appreciate that. And at this point, we will, I don't see any other committee questions. We are going to be moving to a motion to table, but again, as I said, we did notice this as a public hearing, and I just want to check in the attendee space and see if there is any member of the public who wishes to speak on LD 906. If so, please raise your electronic hand and keep it raised. Okay, and it does seem as though there are two members of the public who wish to speak. And so we'll start by bringing Kristen Mail into the panel. And while she's joining us, I did want to let everybody know, members of the public, when you are called upon to speak, you'll be moved from the attendee space into the panel. We will be running a 3-minute clock, and we ask that you respect our time limits because particularly this time of year, we have a very compressed schedule of bills that we're working on. Representative Harnett, co-chair, will be up in the upper left-hand corner of the screen and will be showing you his phone when you're close to the end of the 3 minutes. And with that, Ms. Mail, you can introduce yourself and begin your testimony.
Thank you. Good morning, Senator Carney, Representative Harnett, and members of the Committee on the Judiciary, with a special hello to my representative, Chris Babbage. My name is Kristen Maley. I'm the president of Good Shepherd Food Bank, and I'm speaking in support of LD 906. The food bank played a critical role in responding to the COVID-19 pandemic throughout the state of Maine, ensuring continued access to nutritious food despite challenges with availability and access to food compounded by a statewide heightened need. We also provided access to clean drinking water. The pandemic magnified a number of previously unknown gaps in our food supply chain, but this one, the lack of clean drinking water to fellow Mainers, is the most egregious. We first learned of the lack of access to clean water in March of 2020. Initially, Wabanaki Public Health requested water for 85 tribal elders, approximately 4 pallets. We only had 1 pallet of water at the time. We reached out to the Department of Agriculture, Conservation, and Forestry for assistance, and working in collaboration with them, the Maine Emergency Management Association, our agency contacts, and Wabanaki Public Health, we were able to provide water deliveries twice during the month of April of 2020, again in July, and November, and January of this year, for a total of 10,600 gallons. Last Friday, we met with Sabayak community members to continue the discussion about ongoing water deliveries. One of the women shared with us that she has never been able to drink clean water out of the tap and recalls being told, even as a child, to never drink the water. She regularly fills containers with water at the closest pump, which is 15 miles away, for her family, and also delivers them to many elders within the community. The food bank is now arranging for a full truckload of water to be delivered every 6 weeks, which we all acknowledge is not a permanent solution. As a food bank, and especially one being so close to a major bottled water company, we regularly provide water to not only Maine organizations, but other food banks around the country when disasters hit. I assumed that the Passamaquoddy water issue was somehow caused or related to the COVID-19 pandemic. I quickly learned that this has been a long-standing issue, and I admit I was shocked and ashamed. Ashamed because I've been a resident of this state for over 20 years, and I've never heard of this issue before. And shocked because I cannot believe that we have allowed for a community to go without safe drinking water, an essential element to life, for so long. And I cannot help but ask myself, would this have happened if the town without drinking water was Augusta or Cape Elizabeth or my hometown in Kennebunk? And somehow I think not. While the food bank is willing and able to continue to support these communities with water, this is not our job. This is not an emergency caused by a disaster. This is a community who is simply asking for their most basic needs to be met. So I urge you to please support this bill to restore clean drinking water for the Passamaquoddy tribe at Sabayak. Thank you so much for your consideration of my testimony.
Thank you very much, Ms. Maley. Committee members, any questions? Not seeing any. We appreciate you being here today. And I'll move you off the panel in just a moment, and we'll be joined by our next member of the public, Desiree Vargas.
Good morning, committee. My name is Desiree Vargas, and I'm a councilwoman of Taino Iayagua Tribe. I'm also a member of Bangor City Diversity and Human Rights Committee and a member of Racial Equity and Justice Organization. I testify in support of LD 906. Access to clean drinking water is a basic right. Last year during COVID, there was a call to action for various community members around Maine to help support Passamaquoddy elders in accessing clean drinking water. And so a lot of activists on the ground, such as myself and my colleagues, we gathered clean drinking water to send over to a Wabanaki organization to bring to the Passamaquoddy elders. And that was during a pandemic, right? And this has been going, this has been happening for decades long. It's really a shame that this has to be a bill to testify in support of. Passamaquoddy tribal members have an inherent right to their ancestral waters, in addition to have their water relatives healthy and clean. To be clear, Passamaquoddy people have not been the ones historically making waters unsafe and unhealthy, right? So who will tackle this issue and fix it? The present water system is inadequate. I hope everybody sitting here today is going to choose to make a change. And we have a responsibility as guests on this land to Wabanaki people. Supporting this bill is a step in the right direction and reflects care and support for Passamaquoddy people. Thank you for your time.
Thank you very much for your testimony, Ms. Vargas. Committee members, are there any questions for Ms. Vargas? Not seeing any. We appreciate you being here today and speaking with us. And with that, I'll recognize my co-chair, Representative Harnett.
Thank you, Madam Chair. I move to table LD 906.
Is there a second on the motion? Seconded by Representative Evangelos. And we will move into a vote on the tabling motion. And committee members, we often do this by raising our electronic hands and keeping them raised while our committee clerk completes the voting sheet. And so let's do that in this instance. All those in favor of the tabling motion, please raise your hand and keep it raised.
Eight.
Thank you very much, Ms. Panett. So the tabling motion passes 8 to nothing. And I did also want to, before we move into our next, well, that completes the public hearing on LD 906. And we'll move into our second bill hearing in just a moment, but I neglected this morning to introduce our committee clerk, Ms. Panett, who just appeared on the screen to take our vote on the tabling motion. And then also wanted to introduce two analysts, our usual analyst, Peggy Reinsch, and also Sam Seneff, who has an expertise in Indian law and tribal sovereignty issues, who is joining us also for today's public hearings. Thank you, everyone. And so we will move on now to our next public hearing, and that's on LD 1218. This is another bill that is being presented by our fellow committee member, Representative Newell. And you can begin as soon as you're ready, Ms. Newell, Representative Newell.
Thank you, Madam Chair. Before I go on to 1218, I just want to make a comment in regard to LD 906. I appreciate the committee's consideration and their vote to table. I appreciate the committee's consideration to my summary, although it seemingly came across as beyond what I expected to share, which wasn't what I had anticipated in seeking to have this bill addressed later in the session. So I appreciate the committee's consideration and their patience in my presentation of that bill. It wasn't what I had expected. So thank you. As I go into LD 1218, the same would apply in regards to the resolve to require the Attorney General to provide an update on Maine's implementation of the federal law called Savannah's Act. What we did, again, prior to cloture, as many of you know, in the first session, the 129th, I believe it was 2019, we held on May 5th, which is tomorrow, an event with a number of domestic violence advocates throughout the state and tribal, and we held the very first ever recognition day in regards to MMIWG, murdered, missing Indigenous women and girls, was held at the State House in recognition of May 5th. We could not, because of COVID, hold that in 2020. So it's my understanding that at the fall of 2020, during the last, presidential administration, there was a law, a federal law that was signed called Savannah's Act. So we thought we would continue to give notice to the MMIWG movement that's happening across the United States as well as Canada by putting forth this resolve again before cloture. So we did meet with the Attorney General's office, I believe it was in April, to discuss this resolve. We understand that there is an understanding that there will be another conversation with the Attorney General's office later in this session as the federal guidance comes forth in regards to Savannah's Act. So we're calling once again for this committee's consideration to allow those discussions to continue with the Attorney General's office relating to LD 1218. Thank you.
I was muted. Thank you very much, Representative Newell. Committee members, are there any questions for the bill sponsor about 1218 before we move on to our tabling motion? Not seeing any questions. And this is a bill that no member of the public had signed up to provide testimony on, but I do just want to quickly check in the attendee space. And if there is any member of the public who would like to speak on 1218, and we do have Ambassador Dana who would like to speak on 1218. So I will bring her over to the panel. Welcome to the Judiciary Committee, Ambassador Dana. You can proceed when you're ready.
Thank you. I can be really quick so that you can get about your business on this bill. I just wanted to chime in and thank Representative Newell for her leadership on this and the previous bill. I can deeply appreciate the intentions and work that she has put in on both of these bills today. And I do look forward to the fuller process and public hearings and work session on both of these because they are very, very important. I took part in the event last year on May 5th in the State House for missing and murdered Indigenous women. And it was just very, very powerful for so many survivors and Indigenous women gathering in the Hall of Flags and to see the resolution pass. It was, it made us feel very seen in a world where that's an issue for us. So I would thank you all for your consideration today, and Representative Newell, you're doing beautiful work, and we support you from Penobscot Nation.
Thank you, Ambassador Dana. Committee members, any questions for Ambassador Dana? Not seeing any. We'll take you back to the attendee part of the meeting. And with that, I'll recognize Co-Chair Harnett.
Thank you, Madam Chair. I move to table LD 1218.
Is there a second? Seconded by Representative Moriarty. And committee members, let's again, Representative Libby, are you raising your hand with the question?
I am. I realize there's no discussion of a tabling motion, but I just had a more general question. I know we are limited to carrying over 17 bills and just wanted to get a number of where we will be at after today.
I have not done that count, and that's something that we'll take a look at, not today and not in the context of a public hearing on bills. It's something that we will look at once we get a better idea of kind of where all of our bills are.
Okay, but we will be having public work session on the bills this session, correct, on these bills that we're tabling today with the intention of carrying them over?
Can we talk about the procedural issues at a different time, because I'm just not prepared to have a conversation about the carryovers right now. I've been really focused on kind of the stuff.
Sure, I would like that discussion to be transparent, though. It was disconcerting to learn about the plans for today from someone's Facebook post that is not in this committee. And
Okay.
with that, I can leave it for later, but I'd like it to be.
Thank you, Representative Libby. Okay, so we have a motion that's been seconded to table 1218. And committee members, let's vote following the same process we just followed. Please raise your electronic hand and keep it raised while Ms. Panett records the vote.
Everybody voting? Okay, I get 9.
Yes, that's what I see as well. Thank you, Ms. Panett. So the motion to table LD 1218 passes. That bill has been tabled, and we will close the work session on 1218 and move on to our next bill. And I'm going to put down my electronic hand, and I just encourage other committee members, if you haven't attended to that yet, please do so. The next legislation that we will take up is LD 585. And this is an act to restore the Penobscot Nation and Passamaquoddy Tribe the authority to exercise jurisdiction under the Federal Tribal Law and Order Act of 2010. And it's being introduced by Representative Talbot Ross, and Judge Maynard will also be joining us. So I will bring them onto the panel. Welcome, Representative Talbot Ross, to the Judiciary Committee, and you can proceed with the introduction of LD 585 whenever you're ready.
Thank you very much. Senator Carney, Representative Harnett, and the distinguished members of the Joint Standing Committee on Judiciary. My name is Rachel Talbot Ross. I represent House District 40, which comprises the neighborhoods on the peninsula of Portland. It is my honor to present LD 585, an act to restore to the Penobscot Nation and Passamaquoddy Tribe the authority to exercise jurisdiction under the Federal Tribal Law and Order Act of 2010. In doing so, we keep a promise that we made last session to the tribes of Maine. In 2017, I brought forward LD 766, an act regarding the Penobscot Nation and Passamaquoddy Tribes authority to exercise jurisdiction under the Federal Tribal Law and Order Act of 2010 and the Federal Violence Against Women Reauthorization Act of 2013. During consideration of that legislation, the governor's office requested that we separate VAWA's special domestic violence criminal jurisdiction from the tribal law and order criminal jurisdiction for C felony offenses. We did so with the promise that we would take up TOLOA jurisdiction separately. All too often in our history, promises made to the Native American peoples have been broken. In bringing forward LD 585, we make a statement that we will keep the promises we made. LD 585 restores to the Penobscot Nation and Passamaquoddy tribes the right to hold their own citizens accountable for crimes the state has identified as C felonies. The purpose of LD 585 is to bring Maine law into conformity with federal Indian law and to provide to Maine tribes the same criminal jurisdiction as that which all other tribes exercise criminal jurisdiction have. U.S. Supreme Court Justice Thurgood Marshall wrote in 1980 case on tribal criminal jurisdiction that the power to preserve order on the reservation is an essential element of tribal sovereignty. In enacting LD 585, we take another step to honor the promise made to the tribes that the state of Maine recognizes and respects tribal sovereignty. Madam Chair, with your permission, I would like to ask Chief Justice Eric Mainhart, who is available to provide more technical and legal details should you so desire, as well as to answer any specific questions about this bill at this time. Thank you very much.
Thank you very much, Representative Talbot Ross. And welcome, Judge Maynard. It is wonderful to see you here before the Judiciary Committee today. We'll move on to your presentation in just a moment. Committee members, I know that Judge Maynard is here to answer the questions about this legislation. So I don't anticipate that anybody will have questions for Representative Talbot Ross, but I did want to give people the opportunity if they did have a question. And I'm not seeing any. Judge Maynard, thank you for joining us today. And it is our committee policy that everyone other than the bill sponsor has a 3-minute limit. And we would appreciate you abiding by that. Committee members will likely have questions for you, so to follow up on other items. But you can proceed whenever you're ready.
Certainly, thank you. Good morning, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Eric Maynard. I live in Orono, Maine. I have the honor to serve as the Chief Judge of the Penobscot Nation. I also serve as a contract judge for the Bureau of Indian Affairs, doing assessments of tribal courts across the country on their preparedness for exercising TLOA and VAWA jurisdictions, specifically with regards to the due process safeguards that are in place. My purpose in being here today is to support LD 585 and to answer any preliminary questions you might have about how the tribal court can implement TLOA jurisdiction. A lot of the hard work to prepare for TLOA jurisdiction was done in the last legislature when it passed the Special Domestic Violence Criminal Jurisdiction, or VAWA jurisdiction. In the last session, language was drafted into the VAWA bill, which incorporated the due process safeguards of the Indian Civil Rights Act, as well as certain procedural safeguards which were specific to Maine. The AG's office and the tribes have continued to work on the language with regards to TLOA. They have done a lot of hard work. That work is reflected in LD 1626, really, in the criminal jurisdiction section of there, which should probably be the language that people look to as they're looking at the exercise of TLOA jurisdiction. There's still some more work to be done, but I am happy to answer any questions I can about the tribal court's implementation of TLOA jurisdiction.
Thank you very much, Judge Maynard. Committee members, are there questions for Judge Maynard? And I am not seeing any. Judge Maynard, when we do a second public hearing on this in the second session, we hope that you're able to attend and speak in more detail to the bill.
Thank you. Thank you for having me.
Thank you very much. And at this point, I think that there are some members of the public who had signed up in advance to speak to LD 585. And I would, turning to those in the attendee space and asking tribal leadership initially to please, tribal representatives who are in leadership positions, to please raise your electronic hand if you'd like to speak with regard to LD 585. And Ambassador Dana wishes to speak. While I'm bringing her over to the panel, I would just ask any other members in the attendee portion of the meeting who wish to speak on 585 to please raise your electronic hands and keep them raised until you've had a chance to speak. And Ambassador Dana, welcome back.
Thank you. I might get a little dizzy today with all this jumping back and forth. Good morning again, Senator Carney, Representative Harnett, and members of the committee. I can once again be kind of quick in my testimony. I just wanted to come on screen to share the support from the Penobscot Nation and the appreciation for Representative Talbot Ross and Judge Maynard for bringing this up today. This was part of the previous bill, as Representative stated, and it was, you know, in the negotiations, it seemed to make more sense to make this its own bill, its own vehicle. And I can, you know, really impress upon everybody that this is a way to strengthen tribal sovereignty. This is, you know, this federal legislation that should be available to the tribes in Maine because we are federally recognized and it is not. So this is kind of another step in repairing some of that damage done by the 1980 Maine Indian Land Claims Settlement Act. And I know that we have a whole lot more to talk about on that, so I'll keep it brief. But this bill is supported by the tribes. We understand how important it is to have these jurisdictions over these types of crimes. It will vastly improve our justice process and our communities. Thank you.
Thank you very much, Ambassador Dana. Committee members, are there any questions for Ambassador Dana? Not seeing any. I'm sorry to make you dizzy. I'm sending you back to the attendee space. And we'll next hear from Representative Zager, who will be joining us momentarily. And Representative Zager, I think we can hear you. We're not able to see you. Welcome to the Judiciary Committee, Representative Zager.
Thank you so much. I was having some technical difficulties. How is this?
Perfect.
Okay. Thank you so much. Thank you, Senator Carney, Representative Arnett, and other honorable members of the Judiciary Committee. I am Sam Zager. I am honored to represent the good people of District 41 in Portland. I'm pleased to come before you again, this time to testify in support of LD 585 as co-sponsor, and also for later in the day, LDs 1568 and 1626. I want to humbly thank Representative Talbot Ross and Representative Evangelos for the other bills, for introducing them, as well as the members of the task force for their work. Although I'm not at all an expert in the 90 pages or so of statute in these bills, I appreciate the main points. In our 200 plus years of statehood and nearly 250 years of independence in this country, there's so much that we can have pride in. But these bills highlight some of the ways that we can do better. I believe that these bills offer the people of Maine a chance to gain some honor with respect to the state's treatment of the Wabanaki people. The honor that accrues from keeping promises, fulfilling debts, and righting wrongs. During my travels, I've personally seen how governments in Canada and Australia have started to reconcile their past treatment of the First Nations and Aboriginal people. Putting the people of the Dawnland, Maine's Wabanaki tribes, on par with other American tribes and expanding their jurisdiction for crimes committed on their lands by non-tribal members would be important steps along a similar road. Please permit me to recall for the record excerpted word from the Passamaquoddy tribal representative during a floor speech in the 63rd Maine legislature 134 years ago. In the struggle between Great Britain and America, your people came to us for assistance. You authorized Colonel John Allen to speak to us, and you said, "Believe what he says to you." After many kind words and promises, Francis Joseph, who was the chief of the tribe at that time, accepted his offer. In a few days, Francis Joseph gathered an army of 600 men. The Passamaquoddy Indians faithfully fought for the American people to help them gain independence. Sapiel Soktoma, with 50 members of his tribe, captured an armed schooner in Passamaquoddy Bay, and they ran her to Machias and gave her up to Colonel John Allen. You promised us you would see to our just claims in the future. The Indians who served in that war are passed out of existence, but the Passamaquoddy tribe is still in existence. How many of their privileges have been broken? How many of their lands have been taken from them by authority of the state? Now look at this yourselves and see whether I am right or wrong. I don't mean to insult anybody, but simply to tell you of our wrongs. Lewis Mitchell, the Passamaquoddy tribal representative, spoke those words on the 9th of March, 1887. Although he himself has since passed out of existence, his great-granddaughter is a member of this 130th legislature, co-sponsor on this legislation, and with us today. Representative Rena Newell can bear witness to our state answering her ancestors' call. I thank you very much for your indulgence and your consideration of these bills. Be happy to answer any questions you have.
Thank you very much, Representative Zager. Committee members, any questions for Representative Zager? Not seeing any, just want to express appreciation to you. Oh, we do have Representative Newell wishes to speak. Go ahead, Representative Newell.
Thank you, Madam Chair. Representative Zager, I extend my thankfulness to you in your testimony. Chiwaliwan.
Thank you, Representative Newell, and thank you, Representative Zager. Any additional questions from committee members? Not seeing any. Thanks for joining us, Representative Zager.
Thank you, Madam Chair.
Next, we have one other person who wishes to speak on this bill, Diane Olterzewski, and I will bring her over to the panel.
Thank you, Senator Carney, Representative Harnett, members of the committee. My name is Diane Olterzewski from Belfast, and today I'm representing the Friends or Quaker Committee on Maine Public Policy. We thank you for the opportunity to speak on behalf of this bill. I and other members of the Friends Committee faithfully attended the task force learning sessions during the summer, fall, and winter of 2019, bearing witness as the recommendations coalesced into the original omnibus bill, including these criminal jurisdiction provisions. Many of us spoke in the public hearings and attended work sessions held by the 2020 Judiciary Committee before the shutdown. As we learned then and are pleased to advocate for today, the Federal Tribal Law and Order Act of 2010 expands the jurisdiction of federally recognized tribes over crimes committed on tribal land, whether the offender is native or non-native. This jurisdiction is entrusted to duly certified tribal courts of the Penobscot Nation and the Passamaquoddy tribe, with sentencing guidelines that take into account and work with the criminal code of the state of Maine. When a Maliseet tribal court can be certified, LD 585 could be amended to apply to the Holton Band of Maliseets as well. We know how much time and work was invested by the tribal legal teams and the State Attorney General's office in crafting this legislation, and the Friends Committee urges the committee to vote unanimously ought to pass. Thank you.
Thank you very much, Ms. Olterzewski. Committee members, are there any questions for Ms. Olterzewski? I am not seeing any. We appreciate you being here today. And I'm turning now to the attendee space and asking if there's anyone else who wishes to be heard for, against, or neither for nor against on LD 585 to please raise your electronic hand and keep it raised until I can move you on to the panel. And I'm not seeing any. So with that, we'll close the public hearing on LD 585. Thank you all very much. Actually, we can't close the public hearing yet. Representative Harnett, did you want to make a motion? Oh. We're not able to hear you, Representative Harnett.
I apologize. Thank you, Madam Chair. I move that we table LD 585.
Is there a second? seconded by Representative Sheehan. And committee members, let's follow our usual process on these motions. All those in favor of the motion to table, please raise your electronic hand.
I get 9.
That is what I see as well. Thank you very much, Ms. Panett. And so with that, with a vote of 9 in favor, and actually before we do that, I did want to check in. Representative Poirier is not on the screen, and I just want to check in. Representative Poirier, did you wish to cast a no vote on the table motion, or have you been pulled away to other business? I believe she is involved in other legislative business, and so the vote on the tabling motion is 9-0. And with that, we'll bring the public hearing on LD 585 to a close. Yes, Representative Thorne?
Thank you, Madam Chair. Just as a point of clarification for a freshman legislator, what's the purpose of tabling these after a public hearing, whereas we normally just close them out and they get scheduled down the road for a work session? What was the purpose today of a tabling motion?
The purpose of the tabling motion is that each of these bills needs additional work that we're hoping can be accomplished between sessions. And so we're tabling them now so that that work can take place between sessions. And then when we have an amendment with more definitive language, we actually would schedule a second public hearing in the second session of this legislature so that committee members and members of the public can weigh in on language that is much closer to the language we'll be voting on. It's really to have a robust process when we have more definitive language.
Thank you for that explanation. That helps. Thank you.
You're welcome. Thanks for asking the question. Got a bunch of hands up. Representative Libby, go ahead.
Thank you. So I'm sorry, my understanding was that we would be having work session at some point during this special session on these bills. Is that not accurate? Or are they simply going to be tabled so that they carry over without carrying over and taking up one of the 17 spots?
As I think I'd mentioned earlier, any bill that has not been reported out of committee is potentially a candidate for a carryover, but we haven't really, because right now we're in this intense period of making sure that we complete public hearings on all of our bills, that we really haven't come up with, we haven't really thought that much about what the next steps are with regard to carryover. I know that our colleague Representative Newell did specifically request a carryover on the 2 bills that she presented, and I indicated to her that we would carry those over. I think we've heard the good reasons for that. I appreciate that you're very concerned about the carryover situation. It's not something that I am able to address in the context of these.
Sure, I appreciate that. My follow-up, Madam Chair, if I may.
Yes.
We're in a unique circumstance being in special session at the moment, and I just want to understand the procedure around all of this. So that's where my questions are coming in. This is, as Representative Thorne mentioned, this is all new procedure to those of us who are new to the legislature, and particularly having public hearings and then work session in special session is, I think, also unique. So I just want to be sure that I understand the process that we are undergoing now. So any clarity that you can give to that would be helpful. Thank you.
Thank you, Representative Libby. I can appreciate that it is an unfamiliar process. So we'll provide additional clarity when we've had some more time and information to focus on it.
Thank you.
Representative Moriarty? You're muted, Representative Moriarty.
I raised my hand to vote, but I don't have any questions.
All right, thank you. And Representative Reckett, I just wanted to check in with you too and see if you're raised. Okay. I have a habit of sometimes leaving mine up as well. Thank you, committee members. So we've concluded our work for today on LD 585. And now we are going to open the work session on LD 1568. This legislation has been offered by our colleague, Representative Evangelos. And Representative Evangelos, please proceed when you're ready. And
Thank you, Senator Carney. Senator Carney and Representative Harnett, in reference to LD 1568, I have made the decision not to introduce or present LD 1568, an act to implement the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement and Implementing Act. I do this in the interest of unity around the subject of sovereignty, and I plan to throw my support behind LD 1626, our colleague Representative Talbot Ross's bill on the same subject. As you know, the Judiciary Committee has heard numerous duplicative bills that have slowed down our progress this year. By withdrawing my support and for not introducing my own bill and throwing my support behind LD 26, I hope to facilitate the committee's progress. I am asking the folks in attendance today not to testify on my bill, please. The content of Representative Talbot Ross's bill and mine are quite similar. And with that, I turn the hearing back to the chairs. Thank you.
Thank you very much, Representative Evangelos. For committee members and also for members of the public, I did want to let you know that we'll be acting on Representative Evangelos's request. He is 100% right that the bills, there is much in common between the two bills. And so with everybody's permission, I will call on anybody who wished to speak on LD 1568 and calling on them in the context of the hearing on our subsequent bill. And so with that, Representative Newell, you had your hand raised. Did you wish to speak?
Thank you, Madam Chair. I just wanted to respond to Representative Evangelos in his request to withdraw LD 1568 and was wondering if there was a need to make a motion to his request. And I would like to make that motion and speak to my motion, if appropriate.
Thank you very much, Representative Newell. So the appropriate motion, once a bill has been scheduled for a public hearing, the joint rules prohibit us from allowing a bill to be withdrawn. And so technically what we would do on Representative Evangelos's bill and in response to his request would be a tabling motion, as we have done with other bills. And Representative Evangelos, is that what you were anticipating as well?
Yes, thank you.
Thank you. And so if that helps you frame your motion, Representative Newell. And in addition, I did want to let you know that tabling motions are not debatable. So you could make the motion but not speak to it. Representative Thorne?
Thank you, Madam Chair. I was under the understanding that we had done this in the past and we had gone to direct to a work session to vote ought not to pass versus a tabling motion.
We have done that in the past, and we've also tabled some bills in similar situations. Representative Evangelos?
Two things. In the event, for any reason next year, that LD 1626 ran into some trouble by just tabling my bill, you could like hold it in reserve, but I have no plan or interest in pursuing it. I plan on working on 1626, but I would ask, since there is no tabling motion made, I think Representative Newell wanted to say something. So that's all I have to say, but I'm very comfortable with Senator Carney's decision to have the bill tabled. So thank you for that.
Thank you, Representative Evangelos. And I did want to note that because this bill and 1626 are so similar, this would not be a bill that would be a candidate for a carryover. We have about 170 bills before our committee. We actually only have 17 carryovers, and that's why, for example, we've been combining bills like Representative Moriarty's bills. So I just wanted to let you know that we've been combining similar bills to kind of maximize our the carryover, the impact of the carryovers. Representative Newell, go ahead.
Thank you, Madam Chair. I make a motion to table LD 1568.
Thank you, Representative Newell. Is there a second? Seconded by Representative Harnett. And committee members, we are going to vote on this motion as we have the others by using our raised hand function. So please use your raised hand function if you're in favor of the tabling motion. And if, I think that we will have some no votes on this motion. And so have all those who wish to vote in favor raise their hands. Okay, it looks like we've got the screen is changing dramatically and I'm having a hard time counting. For all those who intend to vote in favor of the motion, please keep your hand raised for a moment and I'll call for no votes in just a second. So it looks like there are 7 in favor. And so those, looks like
8
in favor, excuse me.
Chair.
Okay, thank you very much, Ms. Bennett. So 8 in favor. And now can all of us who voted in favor please lower our electronic hands? And those who are a no on the tabling motion, please raise your electronic hands. And then Representative Evangelos, how did you wish your vote to be recorded?
I voted with the majority, Senator.
Thank you. I was, okay, thank you. I was oversight on my part. And so the Ms. Panett, do you have an 8 in favor of the tabling motion and 2 opposed? Is that?
Yes, yes, I do, Madam Chair.
Thank you. I do as well. Okay, and so with that, we have tabled LD 1568 and the public hearing on 1568 is now closed. And we'll move on to our public hearing on LD 1626 and welcome back the bill's sponsor, Representative Talbot Ross. And Representative Talbot Ross, you can proceed when you're ready.
Thank you. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Rachel Talbot Ross. I represent the House District 40, which includes the Portland neighborhoods of Parkside, Bayside, East Bayside, Oakdale, and the University of Southern Maine campus. It is my honor to present LD 1626, an act implementing the recommendations of the task force on changes to the Maine Indian Claims Settlement Implementing Act. While I am honored to be the lead sponsor of this legislation in the 130th legislature, its current form is the result of a couple of years of work by this committee and the tribal nations. Additionally, I want to acknowledge the co-sponsors of LD 1626, Representative Rena Newell, Senator Carney, Representative Harnett, Senate President Jackson, Speaker Fecto, Representative Martin, Representative Perry, and Representative Collins, as well as the supporters of the legislation who are unable to be co-sponsors, the Honorable Representative Jeff Evangelos and others. LD 1626 is a group effort of many people who strongly support the modernization of our state's relationship with the tribal nations. Today, at this historic moment of reckoning in our state and our nation, we recognize and honor the current tribes who comprise the Wabanaki Confederacy, the Penobscot, Passamaquoddy, Maliseet, and Micmac peoples who have stewarded this land throughout the generations. We respect the traditional values of these tribes and affirm their inherent sovereignty in this territory. We support their efforts for land and water protection and restoration, and for cultural healing and recovery. I ask that you join me in remembrance of the tribes of the Wabanaki Confederacy whose lives and land were taken through genocidal strategies of colonial settlement of this land. We pay respect to elders both past and present, and we commit to the ongoing work of decolonization in Maine and beyond. Yet it is not enough to simply say these words. We must take direct action as well. Our action as lawmakers requires the passage of LD 1626. Madam Chair, I ask your permission at this time to recognize Ambassador Molly and Dana of the Penobscot Nation, and I thank you all for the opportunity to speak to you today.
Thank you very much, Representative Talbot Ross. Committee members, recognizing that we will have an opportunity to hold a second work session on this, I just wanted to check in and see if there were any questions for Representative Talbot Ross. I'm not seeing any. Representative Evangelos, go ahead.
Just a point of clarification. Thank you, Senator. I think you meant to say a second public hearing, correct?
Yes, second public hearing. Thank you.
Thank you.
I'm not seeing any additional questions or points of clarification, which I appreciate, Representative Evangelos. And so with that, we'll turn to Ambassador Dana, and you can proceed, Ambassador Dana.
Thank you again, and good morning again, Senator Carney, Representative Harnett, and members of the committee. I want to extend very deep gratitude to Representative Rachel Talbot Ross, Representative Evangelos, Speaker Fecto, President Jackson, Representative Collins, all of the co-sponsors, champions, and friends of the tribes in the Maine legislature. We appreciate all the hard work and allyship very, very much. I also want to extend another greeting to Representative Rena Newell, serving her tribal nation so proudly in the state legislature and on this committee. I wanted to use my time to bring our attention back to a resolution passed by the Senate on June 10th, 2019. I won't read the whole thing, but I'll walk us through a little bit of it because I think it's really important. This was a joint resolution to support the development of mutually beneficial solutions to the conflicts arising from the interpretation of an act to implement the Maine Indian Claims Settlement Act and the Federal Maine Indian Claims Settlement Act of 1980. Whereas the ancestors of the members of the federally recognized Indian tribes located in what is now the state of Maine have inhabited these lands since time immemorial. And then it goes into the very valid claims to land and why those took place. The disagreements arising from this act have also resulted in the diminishment of rights, privileges, powers, and immunities of the Maine tribes compared to those generally enjoyed by other recognized Indian tribes within the United States. And the diminishment of these things has caused disenfranchisement, undue hardship and suffering of individual members of the tribes and tribal communities that have resulted in the loss of health, education, and general welfare compared to the overall population of the state and the United States. Whereas significant time and taxpayer resources have been spent litigating with Maine tribes rather than focusing on efforts to develop mutually beneficial solutions that allow all of the state citizenry, including its tribal citizenry, to prosper. And whereas the state does not prosper when a specific portion of its citizenry suffers, and the state's resources are better spent on developing jobs, strengthening infrastructure, improving the health, education, and safety of all its citizens. Now, therefore, be it resolved that the legislature supports a collaborative process to develop an act to develop amendments to these acts that would clarify that the Maine tribes enjoy the same rights, privileges, powers, and immunities as other federally recognized Indian tribes within the United States. I'm not sure I can say anything much better than this resolution that was passed in the Senate in 2019. You know, this task force process was initiated by the state. Do I have more time, Madam Chair?
Ambassador Dana, if you could please wrap up, and then the committee members may have questions for you.
Perfect.
Thank you.
This was a process initiated by the state. The tribal chiefs came to the table in good faith. The process has been extensive. It has taken a lot of the time and resources from our tribal communities. We are very ready for a new dawn of tribal state relations. We need to think about abundance and not scarcity. We need to think about being sovereign nations and not municipalities. And we need to really think about healing this relationship in an authentic and good and genuine way. And the tribes are very much ready to do that. Thank you.
Thank you very much, Ambassador Dana. Committee members, are there questions for Ambassador Dana? Representative Newell?
Thank you, Madam Chair. Good morning, Ambassador Dana. Thank you for being here. I know you are speaking against the timer. So I just wanted to ask you if there was anything else that you might want to add. Thank you.
Thank you so much, Representative Newell. I did have a few more notes. I appreciate the time. So my position that I am in right now, the tribal ambassador, only exists because this relationship between the state and the tribes had soured to such a point where we didn't feel it was equitable anymore to have a tribal representative. And I remember being there in 2015 when the representatives walked out, and it felt like we were kind of ending one era and starting another. And it was sad and kind of mixed emotions, but it was also empowering. And I feel that, you know, the tribe's effort to come back to the table to work on these things really can't be said enough how significant that is. And I truly hope that at the end of the day, the words of that resolution that was embraced by state lawmakers can really ring true, and that we can acknowledge the ways that this act has been used to oppress tribes and undermine tribal sovereignty. I was not alive in 1980, but I remember conversations with different family members. Some were for this act and some were opposed to it. And they were both right and they were both valid. And the ones who were for it saw an opportunity that may not have come along again. And they also thought that this document could be amended over time. This document has been studied. It has never been meaningfully amended in a way that will really benefit the tribes and help heal this relationship. So thank you for giving me a little more wiggle room and explanation time. And I look forward to all the future interactions with this committee as we work through this together.
Thank you, Ambassador Dana. Committee members, are there any additional questions for Ambassador Dana? Not seeing any. At this point, I just want to let everyone know how we're going to call the members of the public and others who wish to testify on this bill. We are going to start by asking any tribal leaders to raise their electronic hands. And then after they've had a chance to speak, then we would ask any members of the legislature who wish to speak on the bill to raise their electronic hands. And then we'll turn to members of the public, and we'll have, as we always do, we'll have those who wish to speak for and then against, and then neither for nor against. And co-chair Harnett will be running the clock, which you've probably seen and heard already on the screen today. And so with that, I'll turn to the attendee space and ask any tribal leader who wishes to speak in favor of this legislation to please raise your electronic hand and keep it raised until you've had an opportunity to speak. And I am not seeing any, so I think that Ambassador Dana was the tribal leader who wished to speak on this. And so now we'll turn to members of the legislature. Senate President Jackson is here, and he'll be joining our panel in just a moment. Welcome, Senate President Jackson, to the Judiciary Committee. We're honored to have you here today, and you can begin your testimony whenever you're ready.
Well, good morning, Senator Carney and Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Troy Jackson. I serve as Senate President of the Maine Senate, and I have the great honor of representing the good people of Northern Aroostook County in the Maine Legislature. I'm grateful to appear before you today to pick up where the Maine Legislature left off last year by lending my full support to LD 1626, an act implementing the recommendations of the Task Force on the Changes to the Maine Indian Claims Settlement Implementing Act. To say this bill is a long time coming would be an understatement. LD 1626 is the results of years of hard work by tribal members and tribal leaders, the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act, state lawmakers, and tireless advocates. It seeks to restore tribal sovereignty and self-determination while working to repair the relationship between the state of Maine and tribal governments. Unfortunately, after hours of public hearings and work sessions, this committee's good work was disrupted by the COVID-19 pandemic. A lot of due diligence went into carefully crafting this legislation to ensure our tribal nations are treated with the dignity and the respect that they deserve. Last session's task force gathered a diverse group of stakeholders around the table and then spent more than a year reviewing the Maine Indian Claims Settlement Act of 1980 and working to reach a series of consensus recommendations. Now, it is incumbent upon this legislature to finish what we started so that we can open a new chapter on our state-tribal relations. To me, it's simple. We have a real opportunity to right past wrongs, establish a strong working relationship between the state and the tribes based on trust and shared understanding to avoid future conflict. For years, Maine has not done the right thing by the tribes. Talk of addressing inequality only goes so far. It's time to act. We owe it to our Indigenous neighbors to work together in good faith to pass this legislation thank you for your time. I really appreciate the committee's indulgence. Certainly appreciate all the work that's gone into this by the tribal members, and look forward to working on this with all of you.
Thank you very much, President Jackson. Committee members, are there any questions for President Jackson? Representative Evangelos?
Thank you, Senator Carney, and good morning, Senate President Jackson. How are you today?
Morning. Great. Yourself, Representative?
Thank you, sir. I just wanted to make sure you were aware, despite the COVID outbreak, that the Judiciary Committee did meet all summer in 2020, and we did complete our work, and I think we reported out a 9-2 maybe, or 9-3 ought to pass bill. We were in the bottom of the ninth inning with the bases loaded and nobody out. And the only question I have is, when did you become aware last summer when we were not going to be called back into session?
I think after the, after the 2 times that we went out to ballot and weren't able to get the votes to actually call ourselves back in. As far as the governor not calling us back in, I think I found out the same time the rest of you found out that she wasn't going to call us back in.
But to be clear, Governor Mills did have the power to call us back in to adjudicate on this matter. Is that correct?
She did, but as I said, I mean, the governor obviously has that ability, but I felt it very strongly that this was a legislative matter and the legislature should have called itself in, which we obviously didn't do, not once, but twice. So I certainly think it was a failure all the way around.
Yeah, it felt like with the bases loaded and nobody out, the umpire called the game off and it wasn't even raining. But anyways, we're going to get back to work on,
good analogy.
we are going to get back to work on Ambassador Dana's vision and yours, sir. So thank you for that.
Thank you, Representative Evangelos and President Jackson. Committee members, any additional questions for Senate President Jackson? Not seeing any. We appreciate you appearing before the committee today. And I'm looking at the attendee space, and I don't see any other legislator who wishes to be heard on this bill. And so at this point, just to clarify the process, first we'll have all who wish to speak in support raise and leave up their electronic hands, and then we'll move to those in opposition, and then we'll do those neither for nor against. So now if you would like to speak in support of LD 1626, please raise your hand, and please leave your hand raised until after you've had a chance to present your testimony. That's the best way for me to keep track of everyone. And thank you everyone for being so cooperative. And I am going to bring over first Kira Jasper, and I'll just continue down the list as folks testify. And again, Representative Harnett will be running the 3-minute clock.
Hello.
Ms. Jasper, welcome. You can begin your testimony.
Thank you. Under Wabanaki sovereignty, the land of Maine thrived for thousands of years. Historian Charles C. Mann described the pre-colonial land of the Wampanoag, which is culturally and geographically close to, but distinct from the Wabanaki. Beyond the fields of maize rose a forest of oak, chestnut, and hickory, open and park-like, the underbrush kept down by expert annual burning. The herring-like alewives were so numerous that when mischievous boys walled off the stream with stones, the alewives would leap the barrier and proceed upstream. Though that time is gone, I want to live in a future where the waterways and forests of Maine are that healthy again. Wabanaki nations are the most experienced and valuable caretakers of this land, so they are the best prepared among us to confront the climate crisis that Maine and the world faces. For Maine, recognizing Wabanaki sovereignty is an important and necessary step for the health of the land, and therefore all of the people living on it. The state of Maine has a reputation for being good neighbors with trans people like me compared to other states. It is only right that Maine should be good neighbors with Wabanaki people too. My name is Kira Jasper, and I support LD 1626 and any measure to recognize Wabanaki sovereignty. Thank you for hearing my testimony.
Thank you very much, Ms. Jasper. And can you please tell us the town that you reside in?
Yes, I live in Farmington, Maine, which is the Abenaki name for this region is Amasakanti.
Thank you very much.
You're welcome.
Committee members, any questions for Ms. Jasper? Not seeing any. Thank you for being here today.
Thank you.
Next, we'll have Shirley Hager joining us. So I may just have lost someone in cyberspace. Ms. Hager, if you are able to hear me, please use your link and rejoin the panel. There was some technology glitch. And we'll now be joined by Barbara Brown. Welcome, Ms. Brown. You can proceed when you're ready.
Thank you. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. Thank you for the opportunity to testify today in support of LD 1626, an act to implement the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Act. My name is Barbara Brown, and I live in Portland. I'm here today on behalf of the Maine Unitarian Universalist State Advocacy Network, motivated by our faith tradition's dedication to justice, equity, and compassion in all human relations, and to the inherent worth and dignity of all people. The 1980 Settlement Implementing Act has put the Wabanaki tribes in a category separate from all other federally recognized tribes in the U.S. and has stifled the tribe's right to self-determination, causing both cultural and economic hardship. The tribes in the land we call Maine deserve the rights and powers ascribed to all other federally recognized Indian tribes. I believe this bill is not an instance of our state granting rights, but rather restoring rights long due to the tribes. The Wabanaki are sovereign nations and have the right to make their own decisions for themselves as to how to administer their community in accordance with their own cultural practices, steward their natural resources, and improve their economic conditions. The bill before you repeals or amends the 1980 Act so that current federal Indian law once again applies to the Wabanaki tribes. This bill restores Wabanaki jurisdiction in 4 primary areas, which under the 1980 Act have been suppressed: land acquisition, court jurisdiction, regulation of natural resources, and taxation. It brings Wabanaki sovereignty into equity with the rights of the other 570 federally recognized tribes in 49 states, a restoration long overdue. In part through the provisions of over 150 federal Indian laws enacted during the period Maine has been the outlier, other states have built relationships with the tribes in their states that benefit the tribes, the surrounding non-native rural communities, and their entire state. Passage of LD 1626 would give Maine the opportunity to build the same kind of relationship, bringing increased prosperity to the Wabanaki people, Maine's rural areas, and the entire state of Maine. For all these reasons, I believe the state of Maine has a moral imperative to help restore the Wabanaki people's sovereignty and right to self-determination. And this legislature has an opportunity, both precious and pressing, to provide equity and justice to the Wabanaki people. I urge you to seize this opportunity by voting ought to pass on LD 1626. Thank you for your time.
Thank you very much, Ms. Brown. Committee members, are there any questions for Ms. Brown? Not seeing any, I'll return you to the attendee portion of the meeting. And we've been joined by Shirley Hager. I apologize for the technology glitch, and you can begin your testimony whenever you're ready.
Thank you. I think it was my technology glitch. I lost my Wi-Fi. Thank you so much. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Shirley Hager from Chesterville, Maine, and I'm speaking on behalf of the Friends, also known as Quakers, Committee on Maine Public Policy, the Committee on Tribal State Relations. One of our primary goals is right relationship between the state of Maine and our Wabanaki neighbors and their fair and equitable treatment. So I'm therefore testifying in support of LD 1626. We in Maine have before us a historic opportunity to right 40 years of wrongs done to Wabanaki tribal communities. The terms in the 1980 Maine Indian Claims Settlement Act and the Maine Implementing Act have proven disastrous for the tribes, and this bill is designed to address those wrongs. Since 1980, Wabanaki tribes in Maine have been prevented from benefiting from over 150 federal laws designed to assist and support tribal health, safety, well-being, and self-determination. Wabanaki tribes here also contend with restrictions and complicated regulations imposed by the Implementing Act that are not experienced by the 570 federally recognized tribes residing outside of Maine. As a result, tribes in Maine suffer from disadvantages not found in any other state. The vast majority of states where tribes are located abide by federal Indian law, which this bill proposes. Through provisions and even requirements contained in federal Indian law, many of these states enjoy and celebrate productive relationships that benefit the tribes, the surrounding non-native communities, and the state. Time and again, it has been shown that when the tribes are prosperous, surrounding rural communities are prosperous. This is our opportunity to create this reality for Wabanaki communities, for our rural areas, and for Maine as a whole. The current situation imposed by the state of Maine on Wabanaki peoples is morally and ethically wrong. Because of the restrictive and onerous terms of the Settlement Acts, Maine was the subject of a 2013 United Nations investigation that described inequities rising to the level of human rights violations. Tribal communities only want what tribes in other states enjoy: greater freedom to control their own destiny and to thrive. We have in LD 1626 the means to make this possible. Let's be able to say that this year, Maine took this honorable and meaningful step toward greater prosperity for our Wabanaki neighbors, for rural communities, and for our state. Friends Committee on Maine Public Policy strongly urges you, when the time comes, to unanimously vote ought to pass on LD 1626. Thank you very much.
Thank you very much, Ms. Hager. Committee members, are there any questions for Ms. Hager? Not seeing any, you being here today.
Thank you.
And next we'll be rejoined actually by Diane, Ms. Alterzewski. I'll move her over to the panel. Welcome back, Ms. Alterzewski. You can begin when you're ready.
Thank you very much. Senator Carney, Representative Harnett, and members of the committee. The principle enshrined by LD 1626, namely the primacy of federal Indian law in U.S. tribal relations, outweighs any narrow objection to specific revenue or jurisdiction that the state must forfeit as a result of the bill's passage. Whoever told us these were state prerogatives were misinformed. Others, we now know, were cynically manipulative of the outcome so favorable to the state of Maine in the 1980 negotiation. Please know that Mainers will not be misled any longer. We now know the truth that federal Indian law governs these matters through the trust relationship between the United States and the sovereign tribes and nations of this land. Our many organizations and individuals will persist until justice finally prevails in Maine, and the tribes enjoy the same freedoms, rights, and immunities as all other federally recognized tribes. I speak today as a descendant of European immigrants. Neither the historical we, the settlers who intruded, encroached, deceived, stole, killed, kidnapped, tortured, and then had the gall to pity and despise over 20 generations of Wabanaki people, nor the current we, who might want to duck and hide from the plain truth, neither of these can change the fact that Wabanaki people are the original, free, and independent, sovereign people of this land. They are the only ones who can decide what is in their best interest, consistent with federal Indian law. When the tribes have the freedom to be the stewards of their lands and waters and to determine their own economic development, rural Maine will prosper right along with them, and Maine will at last realize its potential as an enlightened place to live. Until then, there will only be more lawsuits and more anger and frustration. So it's up to all of us in 2021 to build a new legacy of legitimacy, respect, and honor for ourselves and for our children. Thank you.
Thank you very much. Committee members, are there any questions for Ms. Alterzewski? I'm not seeing any. Thank you very much for testifying before the committee today. We'll be joined by John Mattis and momentarily. And Mr. Mattis, if you can activate your audio and video and proceed with your testimony whenever you're ready. Welcome. We can see you and hear you, Mr. Mattis. Go ahead.
Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is John Mattis, and I'm speaking in favor of LD 1626 on behalf of the Committee on Indian Relations of the Episcopal Diocese of Maine. The Committee on Indian Relations has been working for 30 years to improve relationships between Mainers who are the descendants of settlers and the Wabanaki peoples, who are the descendants of the original inhabitants of what is now the state of Maine. We believe that all people are loved by the one who created us all, and that all people, including those indigenous to this place we now call Maine, deserve to be treated with respect, to have their voices heard when decisions are being made that affects their lives. At its 2020 annual convention, the Episcopal Diocese of Maine adopted Resolution 8, which endorsed LD 2094, the bill in the 129th legislature, which incorporated the consensus recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. It is now time for the 130th legislature to finish the work begun by the 129th legislature. Throughout the 201 years of Maine statehood, the Wabanaki peoples have appealed to the good hearts of Maine people and the Maine legislature. Good heart is a phrase used by Wayne Newell, Gisatanamuk, and Mi'kmaq, three Wabanaki co-authors, in the preface to the new book, The Gatherings. They wrote, and I quote, "Our gatherings described in this book fulfilled the promise of our treaties, and they enacted the relationships and the commitments we are all responsible to and for. Our commitment to one another in the gatherings and in creating this book is a model for every good heart to follow and implement. Good heart is a better phrase than the more common phrase goodwill, because good heart speaks to the capacity to care, to empathize, and to take action based on a clear appreciation of the ways that our past actions have harmed, even traumatized our neighbors. The process of the task force on the changes to the Maine Indian Claims Settlement Implementing Act exemplified a constructive consultation process based on mutual respect, as incorporated in LD 1626, Section 24. As we observed the meetings of the task force, we saw a shift in the responses of legislators on both sides of the aisle. They wrestled with what is unjust in the implementing act and what recommendations they should make to the full legislature to bring a more just relationship between the tribes and the state. We saw their good hearts emerge. It is time for members of the Maine legislature to demonstrate their good hearts by listening respectfully to the appeals of the Wabanaki neighbors to correct the injustices of the Settlement Acts of 1980 and passing this bill. Thank you for your time and consideration.
Thank you very much, Mr. Mattis. Committee members, are there any questions for Mr. Mattis? Not seeing any. We'll next be joined by John Banks. And it looks like there's just a few more people wishing to speak in favor of the bill. I just want to let those in the attendee space know if you do wish to speak in favor, please raise your electronic hands. Keep them raised until you're called upon. And Mr. Banks, welcome to the Committee on the Judiciary. You can begin when you're ready.
Thank you, Senator Carney and Representative Harnett, for the opportunity to speak today to your committee. I want to especially thank Representatives Ross and Evangelos for their support for recognizing the tribe's inherent sovereignty. My name's John Banks. I am a Penobscot Nation citizen. I'm the Director of Natural Resources for the Penobscot Nation, a position I've held since 1980. I came to work for the tribe just before the Federal Settlement Act was approved. I've also been one of the Penobscot Nation's representatives to the Maine Indian Tribal State Commission since 1987. The Maine Indian Tribal State Commission has as one of its missions or one of its tasks is to continually review the effectiveness of the Maine Settlement Acts and both acts, Federal Act and the Maine Implementing Act, and to provide recommendations to the governments of the state and the Wabanaki governments to make improvements on tribal-state relations. And you know, since 1987, whenever the Maine Indian Tribal State Commission has looked into these issues, and they have looked into them deeply, they always come back to the same place, which is the main biggest issue that needs to be fixed is that the state of Maine and all its entities and agencies just really need to understand and recognize the tribe's inherent sovereignty. As the Director of Natural Resources of my tribe since 1980, I've also had the opportunity to work very closely with all of the tribes in Maine as they've developed their various tribal governments since 1980. And what is really enlightening to me is how the tribes have grown and changed since 1980. Our tribes in Maine have developed all of the governmental services and programs to serve its citizens. We have police departments, fire departments, health and human services departments, natural resources departments, police departments, tribal administrative units. I think the Penobscot Nation has well over 100 employees, and they contribute immensely to the local area, the Old Town region. And so I see Tom is holding up his phone, which means that I have to get done now. But I do appreciate the opportunity to speak with you today in support of LD 1626. Thank you.
Thank you very much. Committee members, are there any questions for Mr. Banks? Not seeing any. We appreciate you speaking with us today. And that will bring us to our last person speaking in support of the bill is Ms. Ostrowski, who will be joining the panel momentarily. And Ms. Ostrowski, we can, oh, there you are. Welcome to the Judiciary Committee. You can begin your testimony when you're ready.
Thank you. Good morning, Senator Carney, Representative Harnett, and esteemed members of the Joint Standing Committee on Judiciary. My name is Izzy Ostrowski, and I'm the Social Change Advocate at Preble Street, a human services anti-poverty agency with over a dozen programs and services provided across the state. I'm here today to testify in support of LD 1626. At Preble Street, we know that we cannot be doing anti-poverty work if we are not also engaged in anti-racism work. Housing insecurity and homelessness exist today in part due to our country's legacy of racist housing policies. Additionally, oppressive state and federal policies regarding tribal sovereignty have played a harmful role in the extreme levels of homelessness, hunger, and poverty within and among Indigenous communities. Maine is not exempt from the disproportionate racial impacts of homelessness and hunger. Recent racial demographic data from 10 Preble Street programs corroborate this inequity and show that a high percentage of people of color access Preble Street services. On average, 22% of individuals needing to access Preble Street programs are Black, Indigenous, or people of color. 38% of the people who use Preble Street's quarantine shelter, people who are COVID positive or are waiting the result of a COVID test, are Black, Indigenous, or people of color. And lastly, at Preble Street's small specialized shelter for homeless youth, 37% of people using the shelter are people of color. I'm sharing these statistics because they are one example of why tribal sovereignty is so vitally important. Oppressive state and federal regulation of Native tribes, as well as a lack of sovereignty for those tribes, has resulted in worse health and economic outcomes for Indigenous communities in Maine. Exercising control over Indigenous people and land while simultaneously not investing in equitable resources for those communities is the sordid history of Maine's systemic oppression of tribal communities. According to the Wabanaki Alliance, since the 1980 Settlement Act, 151 federal laws have been passed to benefit the over 500 federally recognized tribes across the country. In contrast, the state of Maine has still not recognized the sovereignty of the Wabanaki tribes. Federal legislation ensures tribes inherent rights to govern themselves, but under state law, the tribes of Maine are excluded from that, as well as other rights and protections guaranteed by federal Indian law. Maine's continued history of inflicting trauma upon Indigenous communities does not have to be the future, and this bill would be a step toward prioritizing a future of equity, sovereignty, and healing for Maine's Indigenous tribes. For this reason, Preble Street urgently asks you to vote in support. Thank you.
Thank you very much, Ms. Ostrowski. Committee members, are there any questions for Ms. Ostrowski? Not seeing any. And I did want to let everybody know that we have two more folks who raised their hands to speak in favor of this legislation. While I'm bringing them over, I wanted to announce to everyone that we had actually a very significant number of people who submitted written testimony on this and the other bills that we've done public hearings on this morning. And all of that written testimony will stay connected to these bills and will remain part of the official record on the bill. People, of course, can also submit additional written testimony when we have a second public hearing in the second session on amended versions of these bills. But please do be confident that your original written testimony will stay connected with the bills. And with that announcement, we've been joined by Lisa Pullman, and you can please begin your testimony when you're ready.
Okay, hi everybody.
Let's see, let me just pull up what I'm going to say. So Senator Carney, Representative Harnett, and members of the Judiciary Committee, I am Lisa Pullman, the CEO at the Natural Resources Council of Maine, and I very much appreciate the opportunity to testify in support of LD 1626. NRCM believes that the time has come for the legislature to recognize the sovereignty of the Wabanaki as a matter of dignity, respect, and honor of inherent rights. We reached this conclusion after decades of collaboration with representatives of Maine tribes on a wide range of environmental issues. NRCM has worked closely with Maine tribes on the landmark Penobscot River Restoration Project, legislation that restored fish passage for alewives on the St. Croix River, the law and regulations that protect Maine from mining pollution, legislation to reduce toxic pollution to Maine rivers, and protects sustenance fishing in tribal waters, and increase protections for hundreds of miles of Maine's rivers and streams. NRCM deeply values these collaborative efforts with Maine tribes. We have learned enormously from these relationships. Working with Maine's tribes has been among the most meaningful experiences that our staff have had in their recent professional careers. Passage of LD 626 would provide Maine tribes with the rights and responsibilities of regulating natural resources and land use within the boundaries of Indian Territory or trust lands to the extent provided in federal Indian law. This change would mean that Maine's environmental and natural resources laws would no longer apply on tribal lands, and federal laws would provide the minimum regulatory framework of environmental safeguards. We support this transfer of responsibilities. Based on our experiences, we have come to understand and respect the deep sense of stewardship held by Maine tribes toward the natural resources that sustain life. We believe Maine tribes will bring this stewardship ethic to the task of managing natural resources within their jurisdictions. We would be surprised if the tribes departed in any significant way from the high standards of environmental protection established by Maine's environmental laws and regulations. Indeed, we assume that the level of respect and care for these natural resources would exceed Maine's state standards. With recognition of tribal sovereignty, the tribes may seek federal resources to increase their capacity to assume the range of responsibilities that come with the task of managing the natural resources within their jurisdictions. Collaborative agreements may be required between Maine's natural resource agencies and the tribal natural resource departments. Additional staff resources and capacity building may be helpful, but these follow-on implementation steps can be addressed after the first important step of recognizing tribal sovereignty has been taken. And that is what the legislature can, and we believe should do by passing LD 1626. Thanks very much for the opportunity to provide these comments. I'd be happy to answer any questions you have.
Thank you very much, Ms. Pullman. Committee members, are there any questions? And again, I'm not seeing any. Thank you very much for providing testimony today. And we'll be joined by Betsy Cook.
Hello, can you all hear me?
We can. Welcome. You can begin your testimony whenever you're ready.
Excellent, thank you. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is Betsy Cook, and I'm the Maine State Director for the Trust for Public Land. I'm speaking today on behalf of 31 Maine land trusts, conservation organizations, and natural resource-based businesses who are united in our support for LD 1626. Which moves the state of Maine to properly and rightfully recognize the Wabanaki tribe's inherent sovereignty. Our groups and organizations hold a broad set of values, including ecological protection, outdoor recreation, farmland protection, working forests, climate action, and community-based natural resource protection. Throughout millennia, the Wabanaki tribes have lived in relationship with the land and waters here and have managed the natural resources so that generations can thrive. We believe as a united group that increasing land ownership by Wabanaki tribes is a critical way to advance Wabanaki prosperity, as well as the values that we as land conservation organizations and natural resource-based businesses share. Our position is that the state of Maine should recognize the Wabanaki tribe's inherent sovereignty and that the sovereign rights should have never been revoked and need to be restored. We believe that strengthening the sovereignty of Indigenous peoples over their lands is one of the ways we can address ongoing environmental damage, begin the process of healing the harm of ongoing colonization, and promote prosperity for all people of Maine. Thank you, and we look forward to continuing to show up in the next session.
Thank you very much, Ms. Cook. Are there questions from committee members for Ms. Cook? Not seeing any. Thank you. Appreciate you being here today. And it looks like additional folks are raising their hands to provide testimony and support. I think what we'll do is we'll take the remaining two, and then after that, we're going to take testimony in opposition. Mr. Smith, welcome to the Judiciary Committee. You can proceed when you're ready.
Good morning, Senator Carney and other members of the committee. I'm delighted to be here this morning. I serve as litigation counsel for the Penobscot Nation and have done so for close to 30 years at this point. I am a shareholder at the Portland law firm of Drummond Woodsum. We represent tribal nations across the country. I'm on partial leave from my firm to serve as the Distinguished Practitioner and Residence Fellow at Cornell Law School for this semester. I'm here in my capacity as an attorney at Drummond Woodsum and counsel for the Penobscot Nation. To briefly explain that over the course of the 30 years that I've represented the nation, I have been witness to and entrenched in litigation concerning the boundary between tribal and state authority that has been unrelenting and destructive over time. I am deeply familiar with the cases, and they largely stem from this ambiguous provision of the Maine Implementing Act that provides that internal tribal matters, and then there's a series of examples, shall not be subject to regulation by the state. This provision has generated litigation, and I'll just list the cases, and these are limited only to the cases that have been in the U.S. Court of Appeals for the First Circuit and the Maine Supreme Judicial Court, the courts of appeals. This does not account for the myriad cases that have proceeded before the trial courts. Most recently, Moyant versus Passamaquoddy Tribe, 2021. For that, I'll just list them. Maine versus Johnson in the First Circuit. That Moyant case was in the Maine Supreme Judicial Court. Maine versus Johnson, 2007, U.S. Court of Appeals for the First Circuit. United States versus Newell, First Circuit, 2011. Penobscot Nation versus Georgia Pacific Corp., First Circuit, 2001. Penobscot Nation v. Palencer, First Circuit, 1999. Akins versus Penobscot Nation, First Circuit, 1997. In re Children of Mary J., Maine Supreme Judicial Court, 2019. Francis versus Dana Cummings, Maine Supreme Judicial Court, 2008. Tomer versus Maine Human Rights Commission, Maine Supreme Judicial Court, 2008. Francis v. Dana Cummings, Maine Supreme Judicial Court, 2007. Winifred B. French Corp. Versus Pleasant Point Passamaquoddy Reservation, Maine Supreme Judicial Court, 2006. Francis v. Dana Cummings again, Maine Supreme Judicial Court, 2005. Francis v. Dana Cummings again, Maine Supreme Judicial Court, 2004. Great Northern Paper versus Penobscot Nation.
Mr. Smith, I'm sorry to interrupt you, but it appears that your 3 minutes has passed.
Oh, I apologize. If I could just
you can provide the remainder of the list to us in written testimony.
I would be delighted. I would just say that by contrast, those states where there is a relationship governed by federal Indian law, litigation is few. Thank you very much.
Thank you for speaking with us today.
Thank you.
And that brings us to the last proponent, Caitlin Bernard. And Ms. Bernard, you can begin your testimony when you're ready.
Great, thank you very much. Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Caitlin Bernard, and I am the Natural Resources Policy Advisor for the Nature Conservancy in Maine. I appreciate this opportunity to testify in support of LD 1626. Nature Conservancy is a nonprofit organization dedicated to conserving the lands and waters on which all life depends. We've been working in Maine for more than 60 years, protecting land, restoring rivers and streams, rebuilding groundfish populations, and developing innovative solutions to address climate change. The Nature Conservancy recognizes that Indigenous peoples and local communities are some of the most important partners in the global effort to contain climate change and preserve biodiversity. Often, when it comes to the decisions that affect their lands and waters and livelihoods, Indigenous peoples have been denied the opportunity to participate in meaningful ways, resulting in the exclusion of important rights holders from decision-making processes and in management approaches that do not consider the lessons and solutions offered by Indigenous peoples. As an organization committed to creating a future of healthy lands, waters, and communities, we believe that one of the most effective and enduring actions we can take is to strengthen Indigenous peoples' voices, choices, and actions in natural resource stewardship. This is a major focus of TNC's work around the world. Here in Maine, we continue to learn about the historical and ongoing injustices faced by the Wabanaki tribes. We acknowledge the urgency of addressing these injustices, and we value the work of the Maine Indian Land Claim Settlement Task Force in developing a package of recommendations aimed at doing so. Our support for this bill is guided by what we have learned from the Wabanaki in our past partnerships here in Maine and from other Indigenous partnerships around the globe. It is deeply rooted in our organizational understanding that Indigenous self-determination, as expressed strongly in the UN Declaration on the Rights of Indigenous Peoples, is the foundation for lasting, quality conservation outcomes. The recommendations outlined in this bill represent an important step toward recognizing the rights to self-determination and sovereignty of the Wabanaki tribes in Maine, which the Nature Conservancy strongly supports. We believe tribal sovereignty is critical for the tribes in Maine to achieve in order to regain their equal status to the 570 other federally recognized tribes in the US, and to participate meaningfully in natural resource management decisions. Ultimately, long-term conservation, where both people and nature thrive, is not possible without justice and equity for all people. Thank you very much for the opportunity to testify today. We will, as Betsy Cook said from TPL, be participating along the way and are eager to come back next year.
Thank you very much, Ms. Bernard. Committee members, are there any questions for Ms. Bernard? Not seeing any. Thank you for participating in the public hearing today. And at this point, I'll ask those who are here to speak in opposition to 1626 to please raise your electronic hand and keep them raised. I also did want to note I've been receiving a couple of questions from people who didn't raise their hands during the proponent section. We will, after we do the opponents and then the neither for nor against, we'll do one final opportunity for people to speak to catch anybody who was not able to raise their hand in time. So at this point, we'll move on to opponents of LD, excuse me. Sorry for the interruption. Opponents of 1626 and also opponents who had signed up previously to speak on 1568, which was Representative Evangelos's bill. And we have two people who wish to speak in opposition. The first is Lloyd Cutler, and we'll bring him over to the panel.
Hi, this is Betsy with the Maine Women's Lobby, and we're inviting
Mr. Cutler, it looks like you are here on our panel. And if you could activate your audio and video and begin, we'd appreciate hearing your testimony.
I assume you can hear me. I don't know why you can't see me at this point.
There might be something I can try to do from my end. Give me just a moment. And we're also having a hard time hearing you. It's very faint.
That's not a good thing either. I'm showing 100%. Oh, after all this time. Are you still not hearing me well?
That's much better. Go
Okay.
ahead. If you can activate your camera, please do so, and otherwise you can begin your testimony.
Okay, I just going to try one more thing just to see if that does it. You cannot move
No,
the video while someone has the hand raised. How are we doing now?
We can't see you, but oh, there you go.
That might be a bad that might be a bad thing for all concerned, but there I am. Members of the Judiciary, senators, representatives, and most important to us, members of the Penobscot Indian Nation. In the MIA of 1980, almost 40 parcels of land were made available to the nations that could be acquired and converted to trust. The Penobscots purchased the oldest stream, which is about 20 miles north of the town of Carrabassett Valley and is in the unorganized territory. What happened was that the Dead River Company would not sell Alder Stream unless they also bought our fee land, or their fee land at the time, in Carrabassett Valley, 24,000 acres, which represented half of our town. Thus, what happened was the MIA had a stipulation in it that any land that was acquired within a town, city, or municipality would require the vote of that town to convert that land into federal trust. In fact, LD 159, which is this committee approved only a few months ago, retained that same language requiring a vote of the town for lands to be placed into trust. Before you is LD 1626, which remove all the rights of the town and the state to vote. The nations are asking for sovereignty, which we very much support. They are our neighbors. We have lived together for 40 years since 1980. Not always perfect like any marriage, but we respect the Penobscot Nation. But we cannot give up our right to vote, not at the expense of home rule, which is the pillar of our state and town government. Please understand, we are not asking for an exception. We are only asking that we retain our rights as a town that were given to us by the original MIA. If the desire of the Penobscot Nation is to place their lands in Carrabassett Valley into trust, we will work with them to make it happen. To date, since these laws have come up, we have had very limited conversations with the tribe. Ambassador Mullion has been very helpful in trying to get those conversations going, but at this point, we really haven't talked. We have ideas, and we're pretty sure they'll work as to how this can occur, and we can put their lands in trust should they want. We don't really know that that's what they want. But without our right to vote, there is little reason for the nation to discuss it with us. The town of Carrabassett Valley only asks that we retain the rights that we have now, and more importantly, our citizens deserve it. Thank you. And again, I want to thank you for all the time everybody's putting in, and I hope you can hear me okay.
We can. Thank you very much, Mr.
Or actually, you wish you didn't hear me. I can't tell which.
We're happy to hear you and see you. Thank you for appearing before the committee today. Committee members, are there any questions for Mr. Cutler? I am not seeing any Mr. Cutler. Once again, thank you very much. Next, we'll be joined by Peggy Daigle.
I trust that you can see me and hear me.
We can see and hear you, Ms. Daigle. You can proceed with your testimony.
Thank you. Thank you, Senator Carney, Representative Harnett, and the Committee on the Judiciary. My name is Peggy Daigle, Margaret Daigle. I've worked as a town and city manager in 9 different communities in the state of Maine, from Caribou all the way down to Old Town. Currently, I'm retired. I keep getting called to come back, but I'm staying retired. I am serving as an elected official in the town of East Millinocket. But I also, for the last 5 years, have served on the executive committee for the Forest Opportunities Roadmap for the state of Maine. And I'm also on CEI's capital management board that deals with the new market tax credit. So I've extensive involvement in the state of Maine and the communities of the state of Maine. And I also served in 1999 as Maine Municipal Association's president. So I'm here on behalf of the communities, but I'm here on behalf of the town of East Millinocket as well. I'm not going to read my testimony that I know that you have in written form. My testimony primarily deals with stormwater and wastewater discharge and what any kind of changes to the river classifications would do to impact the town's ability to operate, to grow, and to expand. Also, there's concerns over loss of taxation. So I just want to express to you that I am aware of the fact that there was testimony earlier about the task force work. I certainly appreciate the effort that has gone into the volumes of work that you've put forward. I am a bit disappointed that as a community, we weren't involved in working through some of this task force report, as well as the development of this, the legislation that's going to be put forward. I am happy to hear that you're going to be tabling this or carrying it over, and I hope that you will allow the communities, the businesses, and the industries to be involved. As you know, we have a fairly extensive system of hydro dams on the Penobscot River, and they're critical to the economic viability of the communities in which they're located. And so all of these entities need to have a voice and need to be heard so that we can understand the cause and effect of whatever is being proposed and whatever changes that we might have to be dealing with. I just want to express that to you. I think my concerns have been laid out pretty clear in the letter. Certainly sympathize with the Native Americans and the struggles that they've gone through, worked with Maliseets in Holton when I was up there, the Micmacs somewhat when I was in Caribou. I was there for a short time, and with the Penobscot Indian Nation when I was in Old Town. So I'm fully aware of some of the things that you're dealing with, appreciate the effort, but I would like to see the towns be more involved in how you shape that up. I'm sorry, I took way too much time.
I think you were right on the nose, Ms. Daigle. Thank you so much. Committee members, are there questions for Ms. Daigle? I'm not seeing any. Appreciate you being here today and providing the information.
You're very welcome.
I think the final person here to speak in opposition is Jerry Reed. He'll be joining us momentarily. Welcome
Good
to
morning, Senator Carney, Representative Harnett. Can you see and hear me okay?
We can. Welcome to the Judiciary Committee, and you can proceed with your testimony.
Thank you. Thank you, chairs and members of the committee. I'd just like to appear briefly this morning in light of the direction that the committee has indicated it will be taking with these bills, to indicate that the governor does have serious concerns with LD 1626 as drafted, but our plan will be to share the substance of those concerns next session at the public hearing, assuming they are still relevant at that time. And in the meantime, we intend to continue to work to try to engage with the legislature and individual legislators, and also with tribal representatives in an effort to find common ground on the issues that are presented in this bill. So for the purposes of this morning's session, I think that's all I will offer. And I look forward to continuing to work with all of you on these important and challenging issues.
Thank you very much, Mr. Reed. That was very succinct. We have some committee questions. Representative Thorne, go ahead.
Thank you, Madam Chair. Mr. Reed, just for clarification, were you appearing as opposed or neither for nor against this bill?
I'm appearing in opposition to LD 1626.
Can I follow up if I may, Madam Chair?
Yes, go ahead.
Was there another piece of legislation that you supported that would more succinctly cover the chief executive's ambitions on this, or is it just something that need to go back to the drawing board and start over?
None of the bills that are pending before the committee that address or are designed to address the recommendations of the task force would be legislation that this office could support. Our hope and intent was to work with tribal representatives in an effort to negotiate amendments to these bills or an alternative bill that could be something that we could support. Those efforts have not borne fruit to this point.
Thank you. Thank you, Madam Chair.
Yeah, thank you very much, Representative Thorne and Mr. Reed. Committee members, are there additional questions? Representative Harnett?
Thank you, Madam Chair, and thank you very much for being here today, Mr. Reed. Are you or is the governor's office involved in active discussions with the tribes regarding changes to the bill to 1626 that they would like to see?
Well, we have been talking to the tribal representatives. Those discussions kind of ended abruptly about 10 days ago. I'm not sure why, but we have been talking to tribal representatives over the weeks and months of this session. Yes, and we hope to continue to engage with them.
So to be clear, it is your intention to restart and continue those discussions?
That would be our intention, yes.
Thank you.
Thank you both committee members. Are there any additional questions? Not seeing any. Mr. Reed, thank you very much for being here today and providing your testimony.
Thank you.
And at this point, I'm turning to the attendee portion of the meeting and just doing one final opportunity for those who wish to speak in opposition to LD 1626 or the previous bill offered by Representative Evangelos 1568. If you're here to speak in opposition to either bill, please raise your electronic hand. And I am not seeing any. So next we will turn to those who wish to speak neither for nor against. So neither for nor against 1626 and 1568. Then I see one electronic hand raised, but it's somebody who's already provided testimony. And so at this point, it does not look like there's any more, here's another neither for nor against, I believe. Let me just check in with these folks. Mr. Mattis, I think that you had previously testified. Is that correct?
Yes, that's correct. In favor.
Okay.
Yeah.
Thank you.
I'm not sure what the problem is with raising and lowering hands, but my apologies.
That's all right. Just wanted to check in with you. Thank you. I'm going to put you back into the attendee part of the meeting.
Thank you.
And Ms. Binney, you've joined the panel, and I just actually want to confirm with you that you're neither for nor against. Are you neither for nor against?
Yeah, I'm not speaking in favor of for or against. I just wanted to offer for those who are listening to the hearing a couple of quick comments just for the general public.
Okay, can you introduce yourself and tell us your town of residence and who you represent?
Yes, I am Allison Binney. I live in Bangor. I am also legislative counsel for the Penobscot Nation. And I've been practicing federal Indian law for over 25 years on a national level. I just wanted to point out for committee members, because especially those of the general public, that particularly when you're in a state like Maine, where there isn't a lot of federal Indian law applicable, that it can be confusing to what the tribes are trying to accomplish here. I think the task force report, which was written in a very nonpartisan fashion, does a really good job of summarizing what current law is in Maine, and also talks a little bit about what federal Indian law does. And that is still available on the website. And so I encourage those in the general public to take a look at the task force report, because I think I actually reread it and think that it was written really well and thinks that it provides a lot of general information. And the other thing is, I would also encourage people, even though it's long, to actually read LD 1626. I know the language hasn't been available for very long, but it is written in red line form. So it does a pretty good job of explaining exactly what the tribes are trying to accomplish. And then I just wanted to let the committee members know that there were some limited discussions going on with the governor's office recently. There were new discussions, but there were some deaths in one of the tribal communities. And as is normal for cultural, traditions and customs, we did have to stop those discussions for a period of time, just for the last 10 days. But it is definitely the hope to restart those discussions. So I just wanted the committee members to know that, at least from the tribal side, we do think discussions are important as long as they're done in good faith. But that it was because of some deaths in the communities for why the discussion started.
Thank you very much, Ms. Binney. Committee members, are there any questions for Ms. Binney? Not seeing any. Thank you for providing, for providing testimony today. And I'm turning again to the attendee portion of the meeting. If you are here to testify neither for nor against, please raise your hand. Not seeing any. And now those who wish to Okay, and now those who wish to testify in favor of LD 1626 or 1568, please raise your hand. And keep it raised. We'll be joined by Maureen Druin.
Thank you.
Ms. Druin, go ahead with your testimony.
Thank you so much for letting me testify at the end here. And not afternoon yet, but good day to Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Maureen Druin, and I am Executive Director of Maine Conservation Voters, an organization representing more than 8,500 members and supporters dedicated to protecting Maine's environment and our democracy. Today, I offer testimony in support of LD 1626 from Maine's Environmental Priorities Coalition, a partnership of 32 conservation, environmental, and public health organizations representing over 120,000 members in Maine. And I also submitted testimony. The organizations are listed below. LD 1626 is one of only 10 priority bills that are part of the EPC's shared legislative agenda this year. And because I submitted testimony, I'm just going to read some of the highlights. I also really look forward to showing up again next year in support of this bill. The EPC supports LD 1626 because recognizing the sovereign rights of the Wabanaki nations is central to protecting the air, land, water, and our shared climate future in Maine. Beyond that, the Wabanaki people long predate the United States and have inherent rights to self-govern. We've heard that some environmentalists fear that environmental protections will be weaker on tribal lands as a result of this change. We've also heard that some industry representatives fear that they will be more stringent. These are opposite predictions, which highlight that they are both simply fears. Fears based on a lack of knowledge, fear of losing control, fear of change. We have not heard either of these fears from people who have formed relationships with and learned from the Wabanaki people. From those people, we've heard trust and hope for the healing that can happen when Wabanaki tribal sovereignty is restored. Now, I share this to illustrate the exciting possibilities to which this bill will open the door, but it is not for us or the state of Maine or anyone else to judge what the tribes may do on their lands or decide whether to restore their rights based on those predictions. Those rights are inherent, not for any government to grant or revoke, including the United States and the state of Maine, which have existed for the blink of an eye relative to the Wabanaki tribes. This is a fact that the United States and every other state in the nation respects. It is time for the state of Maine to do the same. The Wabanaki tribes are the original people of this place. There is no better way to protect tribal lands and waters than to restore tribal sovereignty. And next year, we'll be back to urge you to vote ought to pass on LD 1626. Thank you so much for giving me the opportunity to testify today, and I'd be happy to answer any questions.
Thank you very much, Ms. Drew and committee members. Are there any questions? Not seeing any. Thank you for being here today. And I think that we have one more proponent, Phelps Turner, who I'll bring over to the panel.
Good morning. Can you all hear me?
Yes, go ahead.
Great. Thank you very much. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Phelps Turner. I'm a senior attorney at Conservation Law Foundation. We're a regional nonprofit organization that advocates for environmental protections in Maine and throughout New England. And I appreciate the opportunity to testify in support of LD 1626 today. For hundreds of years, the Wabanaki tribes, for whom this land was home long before Europeans first set foot here, have experienced the horrific effects of colonization, dispossession, and cultural genocide. The state of Maine's treatment of natural resources during our relatively short period of statehood has been equally shameful, especially in comparison with the stewardship of the Wabanaki tribes for centuries beforehand. As an organization focused on protecting the environment for all people, Conservation Law Foundation believes that it is essential that communities that have been disempowered, taken advantage of, marginalized, discriminated against, and environmentally overburdened and underserved be empowered to chart their own future in a manner that redresses these injustices. That's particularly the case with respect to the Wabanaki tribes, who have endured such treatment since Europeans arrived in what we now call Maine at least 4 centuries ago. It has become clear that the relationship between the state of Maine and the Wabanaki tribes will never fully be what it rightfully should be and must be without changes to its structure, in particular restoring the full sovereignty and rights to self-determination and governance of the Wabanaki tribes. LD 1626 is another critical step in achieving this end, and we support it. And I'll close by saying this bill marks a turning point in the path toward reconciliation of non-Indigenous and Indigenous peoples in Maine. There's much work to be done, and it'll take many years, but we cannot miss this opportunity to take this meaningful and fundamental step towards reconciliation. Thank you for this opportunity to testify today, and I look forward to participating in additional discussions on LD 1626.
Thank you very much, Mr. Turner. Committee members, are there any questions for Mr. Turner? Not seeing any. Appreciate you being here today and providing your testimony. And now, committee members, there are a couple of people who wish to be recognized who have had malfunctioning electronic hands. So it's just going to take me a moment to bring them on. The next person who we have Providing testimony is Tim Woodcock, and I believe he is in opposition. And then we have one other person who will speak after him, and I don't know what position that person has, but Mr. Woodcock, you can go ahead and activate your audio and video and proceed with your testimony when you're ready.
Yes, thank you very much, Senator Carney and Representative Harnett and members of the Judiciary Committee. I'm Tim Woodcock. I'm an attorney at Eden Peabody in Bangor, Maine, and I'm speaking on behalf of the Maine Forest Products Council, which is a group of forest products members who together have about 8 million acres of land and are responsible for 30,000 and more jobs. In light of the committee's decision to put this bill over to the second session, I'm going to keep my remarks very, very brief. Because of the Maine Indian Claims Settlement Act and the Maine Implementing Act, the tribes have been able to acquire lands in a scattered area across the state of Maine, central, northern, eastern, and western to a large extent. That's a very unusual composition of lands. I can't think of any state in the Union where Indian tribal holdings are scattered in that way. That was made possible in part because of the jurisdictional arrangement whereby the tribes could acquire land, but there would not be a differentiation in jurisdiction. Looking at the bill that you had before you today, I would just flag a couple of things for your attention over the intervening period here. One is there is a definition in here of federal Indian law. And if you think about it, there is no statutory definition of federal Indian law. There is no court decision anywhere that describes what federal Indian law is. And the proof in the pudding here is that if you look at the definition of federal Indian law, it's really quite general and vague, and I would say is very likely to generate an enormous amount of litigation. So I would suggest to you take a hard look at that definition because I think you will find that it's likely to generate a lot of litigation because it's extraordinarily ambiguous. There are also provisions in here that would deem a federal law to be a certain thing or state law to be a certain thing, or would require a certain construction of those concepts. And I would suggest to you those are considered to be legislative adjudication. That's not proper. The legislature cannot direct a court to make a particular determination with respect to the meaning of a general term. So I would suggest you take a look at those. As any reliance that's being placed on those provisions, I think you will find them to be unreliable. I would say that the Maine Forest Products Council would very much welcome the opportunity to work with the tribes and those people who are involved in the task force and all who are interested in this legislation. Maine Forest Products Council has had a very good relationship with the tribes. They've been good neighbors over this broad area that we share together. And so in the interim, we would look forward to the opportunity to work with all of you and the tribal representatives and the governor's office to see if we can't come up with a resolution that works for all. Thank you.
Thank you very much, Mr. Woodcock. Committee members, are there any questions for Mr. Woodcock? I am not seeing any. Thank you once again for providing testimony today.
Thank you as well. Appreciate it.
Next, we'll be joined by David, I think Kota is how you say your last name, who is also here to speak in opposition. And Mr. Kota, you can activate your audio and video and proceed with your testimony whenever you're ready.
Okay, I think I'm on fine. I had a few technical difficulties. Sorry about that. My name is Dave Coder. I'm the town manager of Carrabassett Valley. While we sincerely understand the intent of this legislation, our community finds ourselves in the unenviable position of being opposed to this legislation in its present form. It really unfairly burdens our community as we have 24,000 acres of, or 1/2 of our land base, far more than any other town in the state of Maine that could be affected. There are many concerns with this legislation, including the potential for significant legal challenges and very ambiguous language that at the very least should be amended. The biggest issue that we have with this is the acquisition of trust land is not subject to the approval of state or any local government within the state. I think you've heard this today. This is a significant infringement on municipal home rule in our state. Essentially, a nation with 24,000 acres, or 1/2 of our town's land base, would be created in our town with no vote of our citizens. We would ask all of you, the voters of your respective communities, how would they react to 1/2 of your town's land base being converted to federal land trusts without approval of your town voters? I think we know the answer to that. There's other issues with this involving, it seems like this legislation only pertains to 6 counties in Maine. This seems like political expediency that exempts entire southern Maine from this legislation. It's easy to be in favor of this if it's not going to affect you. It does affect some of us, particularly in some of these rural communities. We're getting very adversely affected by this legislation, and we need to see changes to this legislation. Doesn't mean we're opposed to trust lands. That's not true at all. Some other issues relating to this legislation involves the payment of taxes a payment in lieu of taxes, and there's a lot of issues with that, along with particularly with land use regulation. Our town is a very progressive mountain resort community, dependent on strict guidelines for development. This is too important to leave to an arbitration panel as opposed to a vote of our citizens. Even more concerning to us is Section 5, subsection 6, page 10, the acquisition of additional trust lands. I spent a lot of time on this legislation. If you read all the way through this, it is entirely possible if with this legislation that all of the agreements that we could put in place regarding property tax and land use regulation commission wouldn't even apply with this legislation. That's how many problems there are with this legislation. I think it's been said before, this legislation is nearly identical to the legislation that was introduced in the last legislature. Unfortunately, the legislative task force that was created was very poorly formed with absolutely no municipal representation. We ask that going forward, including work sessions, that this process allows for consideration by all affected parties, including municipal representation. Finally, we are, however, very serious about meeting with the Penobscot Indian tribal leaders to work together, come up with ideas and solutions, almost done, for our mutual benefit. That includes negotiating the conversion of their Carabasset Valley lands into trust lands. We're very much willing to talk about that. We are committed to working to make that happen if given the opportunity, but we need to be able to negotiate in good faith and allow our citizens to participate or vote in this process. We ask you to consider the unfair burden this legislation is placing somewhat entirely on the town of Carabasset Valley. Thank you for listening.
Thank you very much, and thanks for wrapping it up quickly at the end there. We're trying to be fair to everybody who speaks. Yep. Committee members, are there any questions for Mr. Cota? Go ahead, Representative Babbage.
Thank you. Thank you, Madam Chair. I'm sorry I couldn't find my electronic hand there for a moment. Excuse me. Hello, Mr. Cota. Could you help me to understand how Carabasset Valley got to be part of this issue? Mr. Cutler mentioned something about Alder Stream, which I realize is above Eustis and so forth, but was Carabasset Valley part of the original settlement? Or if not, can you help me to understand how?
My understanding, Representative Babbage, is that when this all took place in 1980, the Dead River Company wanted to sell both the Alder Stream Township lot and also their lands in Carabasset Valley. At the time of the Indian Lands Claim Settlement, it was understood, or that's how the legislation came out, that there shouldn't, any acquisition into trust lands should not be made without a vote of the town. So the state, as I understand it, gave significant tax considerations to Dead River Company and purchased for the tribe Alder Stream Township, which was put into trust lands, and the Carabasset Valley lands, which was not put into trust lands. So we have 24,000 acres in our community that is owned by the Penobscot Indian Nation. So that's what took place in 1980. It's fee land, it's not in trust land. This legislation would provide an easy way to make that happen, to go into trust lands. Again, we're not opposed to that, but if we lose the right to be able to negotiate this, we could lose all land use regulation, we could lose, et cetera, et cetera, et cetera. But that's the history of it.
So if I may, Madam Chair, so was Carabasset Valley then incorporated, or was it part of the original settlement, or was it a complementary transaction to the settlement? Do you know that?
The town was incorporated in 1972 before the Indian Lands Claim settlement in 1980. And again, it was intentionally set up to be fee land as opposed to trust lands because we were an organized town.
Okay.
Thank you, Representative Babbage. And again, Mr. Cota, thank you for answering our questions. Committee members, any other questions for Mr. Cota? I am not seeing any. We appreciate you being here today.
Thank you very much.
And it looks like we have taken everybody who wished to be heard on LD 1626 and 1568. And so with that, I will look to my co-chair, Representative Harnett.
I think I saw Representative Collins put a hand up asking to speak.
Yeah, I just saw that as well, and I don't. Oh, there he is. Okay. Thank you for helping me catch that. Representative Collins, we're bringing you over to the panel. Welcome, Representative Collins. Sorry that I did not call on you earlier. I didn't have see your electronic hand, but welcome, and you can begin your testimony whenever you're ready.
Oh, thank you very much. And thank you, Senator Carney, Representative Arnett, members of the Judiciary Committee. I've been between different committees. I apologize for not speaking as a co-sponsor earlier on. I have about a 5-minute break before going back to another bill. So I just wanted to come into your committee really quickly. I did co-sponsor both of the bills, and I want to thank Representative Evangelos and Representative Talbot Ross for their leadership and all their years working on this issue. I am Benjamin Collins. I represent House District 42, which is part of Portland. And I have worked with the tribes for about 20 years on these issues here in Maine. I've also worked with tribes all over the country. What I can say is that anywhere I travel in the United States and I meet with tribes or people that work with them, specifically legal experts, they always talk about how the tribal state relation here in Maine is one of the most adversarial in the country. And they can't believe that we still haven't moved past some of these issues on sovereignty. And quite frankly, it sometimes is, I feel awful when, I have these conversations. And I also feel bad when I'm around the country and some of the local tribes might be at the same place for a meeting or a conference. And when we hear about all the great things tribes are doing in other states and the relationship they have with their state leaders, it also makes me feel really bad being a legislator that we haven't evolved to that point yet. I see no reason why we should hold back on getting out of the way of the tribes and letting them exercise their full sovereignty. Going back almost 100 years ago, Supreme Court Justice Marshall laid out a framework for sovereignty in this country and said that tribal sovereignty predated the sovereignty of the United States of America, that it was inherent. The 1980 Settlement Act took away some of that power. And we need to realize this in the spirit of what happened there. That was claims for land. That's all that should have been negotiated. But to get that passed and to get some federal funding for tribes, there were parts put in that were signed and agreed to here in the state with the Implementing Act and later in Congress with the Federal Settlement Act that dealt with jurisdiction. You have to realize at the time, the fairness issue here that we're discussing today is that at the time, these tribes lived in areas that were already impoverished in rural parts of Maine, but they had other circumstances that were horrific conditions. They had been mistreated by the state for generations. And they, at that time of that Settlement Act, you have to realize the average lifespan of a Native American member here was in the low 40s to mid 40s. I don't know if it was 42, 43 years old, but the conditions were horrific. There was a great desire to sign this. There was a timeline to sign this because at the time, President Carter was ending his term, and he said he would sign a bill, but it had to get to him before he left. So I think the process was rushed. It was a shame that so much was brought in that had nothing to do with the land claims. And last session, this ended when we had the pandemic shut down. There was great support. Yes, I would just say that I hope the legislature continues to support tribal sovereignty and move forward in an expeditious manner with the governor's office and the attorney general to do what's right and do what's virtually done in every state in the country. Thank you very much.
Thank you very much, Representative Collings. Committee members, any questions for Representative Collings? I am not seeing any. All right, I think that concludes the presentation of testimony. Thank you very much, Representative Collings. Oh, I do see one, actually. Representative Newell, go ahead. I'm sorry.
Thank you, Madam Chair. No direct question to Representative Collins, but thank you for taking some time out in between your committees, Representative Collins, to join us here today. I would like to comment, however, Madam Chair, if I may, that there was a request from Ms. Binney to return to the panel, and however, with her understanding, she will not be, but I would like to just note for the committee members that she has left the following. The Chief Francis asks that to direct the committee members to page 10 of LD 1626, which Penobscot Nation believes fairly addresses the concerns being raised by Carrabasset Valley leaders. Thank you, Madam Chair.
Thank you. And Representative Newell, if you could put that information in an email as well and send it to everyone on the Judiciary Committee, I think that would be really helpful for us to have that in writing and kind of more easily recorded and accessible.
Thank you, Madam Chair. I will convey that. Thank you.
Yeah, appreciate that very much. And I think that with that, I will turn to Representative Harnett for a motion.
Thank you, Madam Chair. I move that we table LD 1626.
There's a motion to table. Representative Newell.
If I may second, Madam Chair.
Yes, seconded by Representative Newell. And committee members, let's follow our same process. I'll call for electronic hand raising for those who are in support of the motion, and then for any in opposition. So this is in support of the tabling motion. Please raise your hand and keep it raised.
Eight.
Yeah, looks like we have 8 in favor of the tabling motion. And so can all those who voted in favor, please lower your hands. And then all those who wish to vote in opposition to the tabling motion, please raise your hands.
Representative Libby.
My apologies. I think I have a delay. I'm hearing Peggy first in here and then second in my earpiece substantially later. I believe I missed the opportunity to raise my hand, but I would like to register a yes to table.
Yes to table. Thank you. So that would be 9.
That's what I have as well. Thank you very much. And Representative Libby, thanks for clarifying that. So the motion to table passes 9-2. And Representative Thorne, oh no, okay. And so with that, we'll conclude the work session on LD 1626. And that brings us to the end of our morning's work. It's noon, and so we want to thank the sponsor of two of our bills today, Representative Talbot Ross, and also Representative Newell, who sponsored two of the bills today, and Representative Evangelos, who sponsored a bill today. Thank you all very much for bringing this legislation forward.
Thank you.
And so committee members, we should check in about a recess for lunch. Would committee members prefer an hour recess to resume at 1, or would we prefer a 45-minute recess and come back at 12:45? Ms. Panett, do you want to go ahead, Representative Reckitt?
I'm sorry. I was just going to say, I believe your work session schedule is for starting at 1.
Oh, okay. I thought it was for starting at 10, but you're right. It is starting at 1.
It got revised yesterday. Sorry.
Thank you. Thank you for being more on top of it than I. So committee members, I think that settles it. Let's come back at 1. See you all at 1. And remember, if you are not signing out, to deactivate your audio and video.
Okay, can you say something?
Mute. Hello, can you hear me okay?
Okay, it's the same time. Let me test my headphones.
Perfect.
All right, go ahead, Soupy. Soupy, can you do one more? I plugged in my headphones. I want to make sure they're working correctly. Thank you.
Hello, enjoy your lunch.
Yes, no more lag. Thank you.
Perfect.
2030.
That's correct.
Thank you for your email, Peggy. You're muted.
It's probably a good thing. I'm usually muted. I did get a call about the bills. They're committee reports, so they'll have to be on the calendar, which
Right.
means you won't see them. Okay. Good. I have to run to the printer. I'll be right back.
Yep.
It was kind of nice to have an hour lunch break. I don't know that we've ever had an hour lunch break.
I don't think we have.
It's used to be the way of the world.
Yep.
Not our world.
No, that's true.
No.
One more document.
So am I correct in looking at just 3 work sessions this afternoon?
Yes, as to work sessions.
But you've got some other things lined up for us.
Don't blame me, Peggy. We've got 55 language reviews.
Okay, that's right.
Peggy has been hard at work on language reviews for us to help us get bills reported out of committee.
Yep.
And we're hoping you're going to vote 3 bills today.
It's that little line, Representative Moriarty, underneath that says other bills to be determined, amenities, reviews.
Yeah, it covers a multitude of sins.
I'm trying my best to get amendments that will review to you at least 24 hours in advance.
Much appreciated, Peggy.
I know you're really busy and that might not be sufficient, but we're all doing our best.
Yep.
I think that 7 technically is a quorum. Maybe we'll wait another moment or two to see anybody else is able to join us. And Peggy, we're going to start with 10:30, right?
Yes, please.
Okay, great.
Right, and actually Professor Deidre Smith from the law school is here to help us with that. You worked through that bill almost all the way to the end, and there were a couple of amendments that were offered by the judicial branch and DHHS. And I'm sorry that Representative Reckitt isn't here right now because she raised a concern about one of those amendments, and you asked the folks to go back and kind of rethink them, and they did, and they've dropped out the provision that Representative Reckitt was so concerned about.
Okay, great. Well, let's do this. It's a little after 1, and Professor Smith is here for 10:30. So let's open the work session on 10:30. And we did have a work session a couple weeks ago and ended up tabling this in order to give Peggy some time to work on the amendment. And so, Peggy, do you want to give us take it away?
Thank you. And I'm going to be really skimpy here. And if you need more, let me know. Oh, good. Representative Reckitt's here. So this bill came from FLAC. It's an act to expand courts' authority to protect children when a parent has been awarded sole parental rights and responsibilities. And it dealt mainly with authorizing a termination of parental rights action or a motion in a very narrow category of circumstances that don't really, where there isn't specific authority in the statute now. The law court has recognized that there should be a way for a parent to ask the court to terminate the other parent's parental rights. And they asked FLAC to come up with a process that would do that, that would keep it very narrow, make sure that the due process of the parents are protected. And it would have to be a very narrow situation. And the situation they focused on was when there's already been an order of sole parental rights. So one parent has all the rights to make decisions, get information, everything dealing with the child. The other parent has no rights to any of that other than they might have an obligation to pay child support. So if an order like that has been in place for at least 12 months and the parent who has the parental rights believes that the language is, and of course it's not jumping out at me, that it's necessary to terminate the other parent's rights to protect the child from serious harm or the threat of serious harm, then that's an action that can go forward in the court. And so that's what this bill does for the most part. There are a couple of other little pieces. It's grafted onto the existing law that allows a parent to terminate the parental rights of a child, parental rights to a child when that child is it was conceived through a sexual assault. That's current law. You can do that now. This adds one more option to using that process to terminate the other parent's rights. The other two ways to terminate a parent's rights are through the adoption process and also the child protection process. So those are different ways. This would be the only other way that the court would recognize a way to terminate another parent's rights. The very first section of the bill deals with a slightly different situation. There's been an order, a sole parental rights order, and the person who has that order dies. And so now you have, you kind of have a situation in the statute where the statute says when one parent dies, all parental rights devolve to the other parent. Well, you already have, that's kind of in conflict with this order that was issued. But the order terminates when the parent dies. So in order to make sure that you don't have a child who it was already determined it would be a bad situation for the child to be with that parent. This gives the probate court the ability to hear a petition from somebody else who wants to have a guardianship over the child, rather than the child immediately being returned to the parent whose parental rights were not terminated, but they didn't really have any. I didn't explain that very well, but that's basically what this bill does. And then the judicial branch was concerned about making sure that when you have a case like this going through the district court, that those proceedings are the default is that they're private, that they're not open to the public unless the court thinks it's necessary to open them to the public. So that was one of the amendments. There was another amendment to make sure that in the definition, it was trying to address the definition of abandonment, that the parent who had no rights, the parent's conduct was demonstrating an intent to permanently forego all parental rights or relinquish parental claims regarding the child. And DHHS, in wearing their child protective hat, said can we tie that into when it results in harm or threat of harm to the child? Flack looked at that language and said that makes sense. That's kind of part of the flow of this. What there was pushback at the last committee meeting was DHHS had recommended that when these cases are going on, because one parent is making an allegation that keeping the parental rights wasn't protecting the child from serious harm or the threat of serious harm. So does that mean the judge should be a mandatory reporter? They suggested that language. The judicial branch, the judges were very uncomfortable with that. They think they make referrals when it's necessary, and they asked that not be included in the statute. And Representative Reckitt had raised some concerns about that from a kind of a domestic violence perspective. And Flack worked with the judicial branch and DHHS, and Deirdre Smith was one of the main go-betweens, I think, and they agreed not to ask for that language in the bill anymore. So you have a shorter proposed amendment that would make 2 changes. And I did send that out, and I can screen share it if you want. It would add a paragraph G at the top of page 3, which says proceedings and records under this section are not public unless the court orders otherwise. The Supreme Judicial Court may adopt rules governing requests for access to these proceedings and records. And then the other provision is also on page 3, and it's in subsection 3A, paragraph B, subparagraph 2, division A, where, is that right?
Mm-hmm.
A, yes, and we'd add in at the end, claims regarding the child when it results in harm or threat of harm to the child.
Committee members, would it be helpful for Peggy to screen share the amendment? Seeing some nods. Peggy, do you mind doing that?
No problem. I have it right up, so.
Section 2.
So this is what would go, on a new paragraph G at the top of page 3. That's part of subsection 2A, the procedure on petition to terminate parental rights and responsibilities. And then
Peggy, when you're referring to page numbers, you're referring to the original LD?
I'm referring to the original LD, and you might not have that in front of you. And I have that. I can share that instead if you want. I don't think I can share both.
No, I think I have it on my computer, but paragraph G that's being added is being added to section 1A, isn't it?
No, it should be 2A.
2-A.
You're right. There could be room for a paragraph G in 1A, but this is going to subsection 2A because it's part of the procedure that the court's going to follow on when somebody files a petition.
It's the top of page 3. I was on
The top of page 3.
Thank you. Sorry. And then where did you say the Second Amendment was?
So the second one is also on page 3, and it goes on line, you insert it at the end of line 25 before the semicolon and the or.
Okay.
So the division is going to read, the parent's conduct demonstrating an intent to permanently forego all parental duties or relinquish parental claims regarding the child when it results in harm or threat of harm to the child.
Okay. Thank you.
That was helpful, Peggy. Committee members, would anybody like Peggy to screen share the original bill so that we can't have them both up on the screen, but if it's helpful, we could have Peggy share the original.
Yes, no? Sounds like no.
It sounds like no to me as well. Okay, good.
Okay, I'm going to stop sharing so you can, but I can pull it up anytime.
So to be clear, these issues were the bones of contention, but the parties they're all on the same page now, the court, FLAC, and DHHS.
That's my understanding, yes. Professor Smith is the one who kind of spearheaded the negotiations and got them to the same place.
Committee members, does anybody have any questions for, or would anybody like to hear from Professor Smith? Representative Poirier? Yeah.
Thank you, Madam Chair. I have a question for Peggy. It's where this is such a complex bill. When parents are able to terminate rights of another parent, does that also terminate that parent's responsibilities to financial responsibility, child support, things of that nature as well?
It does.
So the child would have no financial.
Which is one of the reasons why DHHS was interested in this on two parts. One was the child support and one was child protection. And I think FLAC was very concerned about this as well. One, terminating parental rights is a very permanent, big thing, and you don't do that lightly. But also, are you leaving the child in a better situation with those rights terminated? And that's, so the court is looking at that as well. But once the rights are terminated, there is not an obligation to provide child support.
Okay, thank you.
And kind of along those lines, FLAC made this as strict as it is because they wanted to make sure it wasn't being used by anybody just to get out of paying child support, that it really had to be a situation where this parent was not only not involved in the child's life because they had the sole parental rights order issued, but because the termination was necessary to protect the child from harm. And so just not wanting to pay child support would not rise to that level. But you're absolutely right that terminating the parental rights means there's no obligation to pay child support.
Thanks. Can I ask, well, I don't know if it's a question or more of a, I guess I'm looking at it from a different angle. I'm not looking at it from somebody trying to get out of child support. I'm looking at it from maybe a child's view as far as my parent should be supporting me and I have rights to have the funds coming from that parent versus them trying to get out of it. Somebody's taking that right to the funds away from me. I guess it's just a different way to look at it. Thank you.
Right, and I'm trying to see, and this is where Professor Smith might be really helpful in talking about the best interest of the child and where that comes into this discussion.
Representative Poirier, would you like us to bring Professor Smith into the conversation?
Sure, he might be able to provide more information on that. I'd appreciate it. Thank you.
Yeah. Soupy, could you please bring Professor Smith in? I don't have the authority to do that. Okay, thanks, Peggy. Welcome, Professor Smith.
Good afternoon, Senator Carney. I'll just pick up, I think Peggy framed the answer to the question really well. I will just add that a separate determination in addition to finding that there is a threat of serious harm or serious harm is the court does need to make a separate best interest determination. And in any kind of a parental rights and responsibilities case, Representative Poirier, whether it has to do with initial parental rights and responsibilities, assigning child support, any time that the court's making those types of determinations, they are considering the best interests of the child. And there is a subsection of 19A, section 1653.3 that has a long list of considerations that a court must take into account, as well as a catch-all that says all factors having a reasonable bearing on the physical and psychological well-being of the child. So there isn't an express provision about sort of the children's right to be supportive, but it is absolutely recognized as being part of family law. But as Peggy pointed out, one of the reasons why FLAC suggested really such a narrow opportunity for termination of parental rights by one parent against another was very much all of a child's interest potentially in not having their relationship with another parent severed. The right to ongoing support and potential inheritance and other things are just one component of it, particularly if a child is very young. So it really is an extreme remedy that is intended to be used only in narrow circumstances. As we've explained before, these termination of parental rights proceedings are already happening in the district court because, as Peggy pointed out, the Maine Supreme Judicial Court about 15 years ago said there was nothing in Maine law that stopped a court from being able to terminate parental rights and by one parent against another. And so it's been in this very state of flux where there haven't been clear standards, there haven't been clear procedures. And that's the reason why the judicial branch asked FLAC to study it and determine when, if ever, should there be the opportunity for termination of parental rights by one parent against another. And LD 1030 reflects the results of that examination. I hope that answers your question.
Thank you.
Can I just ask Professor Smith, so does this bill then actually, as compared to the status quo, does it actually limit the discretion that a court would have to terminate parental rights upon petition by another parent?
Yes, Senator Carney, I a couple of weeks ago, I looked at the title of the bill and I thought, I don't think we're really expanding anything because courts, yes, already have the authority to terminate parental rights in a petition by one parent against another. It is clarifying it, and overall, it is definitely narrowing the discretion of courts, or it's narrowing the standards that courts can use before they can terminate the parental rights based on such a petition. That's correct.
And does it also add procedural safeguards?
It does. And that was one of the other, so there were really two major concerns that the courts had about these proceedings happening in the absence of statutory clarification, really two urgent matters. One was the standards, under what circumstances and what's standing, what should be, can this be an initial proceeding? The first time the parents are going to court is the termination of parental rights proceeding. So that there is that question. And then the procedural safeguards were not spelled out well. They're spelled out very well in the Child Protection Statute. They're spelled out very well in the Adoption Act. which, as Peggy explained, are the other two contexts in which there can be a termination of parental rights, but they weren't as clearly spelled out in these types of contexts. So that was the second purpose for the recommendations in 1030.
Thank you. And I've been monopolizing the conversation. Other committee members had their hands raised. Go ahead, Representative Reckitt. And then actually before that, Representative Poyer, did you have any follow-up questions?
No, I forgot to take my hand down. Sorry.
No, your hand was down, but I just wanted to check in with you because you, okay.
I am all set. Thank you.
Yeah, Representative Reckitt? I think you're still on mute, Lois.
I'm not sure that what I want to know is relevant to this bill. So I think I won't ask the question, which I'll have to ask of an attorney sometime, somewhere. But I don't think it's relevant to this bill, so I'll be quiet.
Okay, thank you. Representative Moriarty?
Thank you, Madam Chair. Professor Smith, you mentioned the magic word inheritance. And so I'm wondering if you have a parent who has essentially cut all connections and disappeared from the scene, is that parent still free to, by will, devise a portion of his or her estate to the child? That's one part. The second part is, do the intestacy laws, should that absent parent die without a will, override the termination of responsibilities?
To answer your second question first, because of the way that there's an already existing statute that says what the impact of termination of parental rights is on inheritance, and this goes both ways. And unless something is specifically reserved by the court, there is no inheritance under intestacy laws by either the parent or the child. There have been instances in the past where there was, before that statute was enacted, where there was a termination of parental rights and then the child actually predeceased the parent, and under intestacy, the parent inherited, and many people thought that was an inequitable result. So that's now been clarified under statute. So for intestacy laws, there would not be inheritance unless there was a special provision made by the court. However, as you pointed out, even a parent who's had their parental rights terminated absolutely can devise any form of inheritance to their former child, their legal former child, under will if they want to. There's nothing that's going to limit any of those powers that a person has to name who they want in their will.
Okay, thank you. Madam Chair, I have a second question unrelated to the first. I can hold for the time being and let somebody else take the floor.
Yeah, that's kind of you. Let me just check in. Committee members are there. Before Representative Moriarty asks his additional question, are there any other questions about LD 1030 and this proposed committee amendment? I'm not seeing any. Go ahead with your question, Representative.
Okay, thank you. Professor, I'm looking at the second proposed amendment, and if you have that before you, you can see that the subparagraph ends in new language in boldface. And I'm just wondering what does that add to the substance of the law? Why is that necessary? And to be specific, suppose a parent after divorce goes to California for 10 years, there's been no contact ever since of any type whatsoever. And then what I'll call the custodial parent passes away. If the first parent's conduct has demonstrated an intent to permanently forego all parental duties and relinquish rights and so forth, isn't that in and of itself enough without the threat of violence or harm?
So Representative Moriarty, the amendment is only about the termination of parental rights between parents. So there would still need to be two living parents, one petitioning to the other for the language that is in that amendment to have any effect. Your hypothetical was asking about a situation where a parent had died, if I heard you correctly. And then we would be talking about a minor guardianship circumstance. And the proposed language in this amendment would not change anything that FLAC has proposed about the guardianship. Essentially, what would be most important in that circumstance is for the probate court to have the authority to enter the guardianship because of the sole parental rights and responsibilities order that was in effect at the time of the custodial parent's death. Did I understand your question correctly? So yes, the language in the amendment is only in those petitions where there's two living parents. And the purpose of that additional language is to clarify that, let me just back up for a moment. Under Maine law, there are many different ways that we can find a parent to have abandoned a child, right? Under the child protection statute, there's a definition of abandonment, which has a list, one of which is not paying child support for 6 months, for example, or not having contact with a child for 6 months. And FLAC was concerned that that standard really was far too broad for this narrow circumstance, where a parent's rights would be terminated because of the threat of serious harm to the child. However, there are some circumstances where an intentional relinquishment, essentially, of your parental rights and responsibilities can constitute a form of harm to the child. It could be a very intentional rejection of a child, for example, just repudiation of that that's done through affirmative conduct, such that it would be harmful for that parent to continue to have parental rights and responsibilities of any kind with respect to the child. That language that was added in the amendment simply clarifies that.
All right, thank you.
You're welcome.
Committee members, are there additional questions for Professor Smith? Is there committee discussion on the proposed amendment? There are questions for Peggy regarding either the amendment or the bill analysis. Representative Moriarty, did you have another question?
No, but in the absence of anyone else having apparently a desire to ask, I'll make a motion to issue an ought to pass as amended recommendation.
Thank you, Representative. Is there a second to the motion? Seconded by Representative Harnett. Any discussion on the motion, committee members? Peggy?
Actually, Professor Smith raised an interesting question about maybe the title's a little bit misleading. So maybe in addition to, if you're going forward with this amendment, we adjust the title to say an act to clarify court's authority as opposed to expand.
Yeah, I think that's an excellent suggestion. And Representative Moriarty, do you accept that as an amendment to your motion?
Yes, I do. I will incorporate that. Sure.
Great. Yeah, because I think that to me, that was the big sort of brain shift in looking at this bill, was that it's actually, and Representative Poirier, you helped me understand this as well, is that it's not actually expanding the authority, it's kind of defining it and limiting it and adding some more procedural safeguards, which I do think if you're taking that extreme step of allowing termination of parental rights, that's all very appropriate. Any discussion on the pending motion, committee members? Are we ready for the vote? Looks like everybody's ready for the vote. Thanks, Ms. Panett.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kine. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Representative Newell, I don't think we heard your vote.
I think it was in the process of muting and unmuting. Sorry about that. I vote yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 8 members voting in the affirmative, 3 members voting in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. For those who voted no, could you please tell us what your report will be?
Not to pass.
Thank you very much. And so the motion carries 8-3 with 3 absences, ought to pass as amended. That concludes our work session on LD 1030, and a special thanks to Professor Smith for being with us today. And I think we can move on to the next work session, Peggy, which is 11:02. Is that the one you'd like to take up next?
Yes, thank you. So 1102 is Senator Bailey's bill about the preliminary injunctions in divorce and
Representative Thorne, I think you're there you go. Thank you.
So LD 1102 is about expanding and making more specific the preliminary injunction that is issued when a divorce is filed or a judicial separation is filed. And you had a hearing and people testified in favor of it, but there were some questions about kind of the language and some of the specificity, and you asked FLAC to look at it. And FLAC took it up at their meeting in April. Must have been March. Anyway, my calendar still says April, so I'm a little behind. In April, and said, this is a great topic. We really want to work on this. We do not have time to do it this session. If you direct us to do it, we will report back. So what I've drafted, and FLAC supports this amendment if you want to go forward with this, is an amendment that would strike the bill and turn it into a resolve, and instead direct the Family Law Advisory Commission to work with anybody who's interested, but to look at the preliminary injunction, look at it in other states. There is actually a uniform act that applies in this area, but they would look at other states and how they deal with particularly the issues that were raised in the hearing, which is use of retirement accounts or IRAs or 401ks, as well as there was a concern about extraordinary expenses. And so FLAC was actually very interested in working on this because they feel the current law is inadequate, but they're concerned about just dropping this into the statutes without more work. So I did send out that amendment. I'm happy to share it if you need me to do that.
Yeah, Peggy, could you please share it for us? Thanks.
Very short. So it strikes out the bill, changes the title to a resolve, and the commission would submit a report back to the Judiciary Committee no later than December 15th. And then you would be able to report out legislation to the second regular session to incorporate any of those recommendations.
Thank you. Committee members, are there any questions for Peggy regarding the language of the resolve? And I can't, in screen share, I can't see actual hands. So if you can use your raise hand function, please, if you have a question.
I'm going to stop sharing.
Yes, please, because I don't think there are any questions on the language. And so Peggy, I know that there were a couple of examples of why it was important to consider an injunction and why the situation is a little more complicated than the original bill indicated. Can you just give us one of those examples, please?
Well, one of the examples that Representative Cardone mentioned was, so the bill says stop making any payments out of 401ks. Well, if somebody is already receiving distributions from their 401k, and that's what they're living on, this would stop that process. And that's really not the intent. The intent is to freeze assets so nobody's spending them down, so to avoid there being a fair sharing of the marital assets. So that was one of them. How do you deal with the bill says you can't do any distributions. How do you deal with those circumstances where the distributions make sense or have been happening and it's actually an equitable thing for the distributions to continue?
And that's what would essentially be sorted out in the study.
That would, yes. And actually it was really interesting because I sat in on the FLAC meeting and they talked about how specific some of these things were. And I really can't remember exactly which, they weren't all on board with all of them. And they really wanted to talk about them and also see how they're working in other states. Senator Bailey said this came from Oklahoma. And so they'd like to reach out and see if this is working in Oklahoma.
Thank you. I see that Representative Reckitt has a question.
Yeah, I just wanted to, as you were talking about distributions from IRAs, my presumption is they would want to caution around mandatory distributions, which happen when you get to be my age and slightly younger. So if you don't take your mandatory distribution, then there are penalties. So it seems to me that that's one of the words that ought to be in there as a exception or whatever.
Right. And I think that they're aware of those issues and it's just not taken into account in the bill.
Right. Thank you.
Committee members, are there additional questions for Peggy? Go ahead, Representative Libby.
Thank you, Madam Chair. I think I'm a little bit slow on the uptake here today, Peggy. I just want to verify. So we're basically transitioning this whole thing from a bill to a resolve. Okay. And so where it says in the amendment, amend the bill by striking out everything after the enacting clause and inserting in its place the following, which part is the enacting clause? That's what I'm trying to figure out.
That's great. So I love bill pieces. The enacting clause is actually at the very top of page 1, be it enacted by the people of the state of Maine.
Okay,
That's
so it's
fine.
just literally that piece, that's it.
Right.
And then section 1 replaces everything following line 1.
It takes everything from the enacting clause to the summary. And then of course,
Okay,
all
and
done.
so section 1 and the summary of the amendment are the sum total of this resolve now.
Right. So if this were enacted, you would have a resolve that would have just this as part of it.
Thank you very much.
Representative Harnett?
I would make a motion ought to pass as amended.
Thank you, Representative Harnett. Is there a second? Seconded by Representative Moriarty. Any discussion on the motion? Not seeing any discussion. Thank you, Ms. Panett, for joining us to take the vote. And this is on the ought to pass as amended motion that will change the language of the statute into a resolve to ask the Family Law Advisory Commission to review the issue of preliminary injunctions and report back to our committee.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Thorne. Representative Thorne is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 are absent.
Thank you very much, Ms. Panett. And so the ought to pass as amended. Motion carries 10-0 with 4 absences. Representative Libby?
Thank you. And I probably should have made note of this during the discussion, but I didn't think of it. I just wanted to mention that as FLAC is doing their work on this, it would be nice if the judicial branch could be incorporated before the bill even comes to us, as they'll probably have input or feedback regarding whatever comes before us.
So if I could just answer that just real quickly. I think the judicial branch will be involved. The chair of FLAC is Mary Kelly, who's a district court judge. And the cadres, the mediation director is part of FLAC. There's also a Superior Court Justice, Justice Douglas, Wayne Douglas is a member. And the Family Division Administrator, I'm not exactly sure her title, Carolyn Hova, always participates. So the judicial branch is definitely plugged in, and also Judge Libby Mitchell, who's a probate judge, is a member. But that's great to, remind them that there's lots of entities that need to be participating.
Thank you. I just want to make sure the discussion around
All right, and so the work session on 11:02 is completed, and so we'll close that work session and move on to the next work session, which is on 9:08. And Peggy, do you need an update from me?
Yes, I'm not sure that I hadn't heard the latest on what Representative Warren was hoping would happen with her bill.
Okay, so for Peggy and for all members of the committee, Co-Chair Harnett and I have been in touch with Representative Warren. She did pursue seeing if other committees would accept a re-referral of this to either Transportation or Criminal Justice and Public Safety. And for various reasons, neither of those committees were able to take on the legislation at this time. Representative Harnett?
I was just going to add that she had asked, Representative Warren asked for the bill to be withdrawn, and I indicated that was not possible since it's already gone through a public hearing, and that I would be moving ought not to pass. So whenever the committee is ready, I'm ready to make that motion.
Is the committee ready for the motion? Go ahead, Representative Harnett.
I move ought not to pass on LD 908.
And is there a second? Seconded by Representative Libby. We're ready for the vote, Ms. Panett, whenever you are.
Ready right now. LD 90, can't even talk. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Representative Thorne. Representative Thorne is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent.
Thank you very much, Ms. Panett. So the ought not to pass motion carries 8-0 with 6 absences. And for members of the public who might be watching or listening in, committee members who are absent do have the opportunity to vote on legislation, even if they've missed the work session. So the vote on each one of these measures could change a little bit over the next 48 hours. And so that concludes our work session on LD 908, and we'll move on to the next bit of work that we have. And Peggy, I'm going to let you give us a little direction here, if you would be so kind.
Okay, well, I mean, obviously this is however you want to make this work. We have several amendments that are ready to be reported out if you approve of the language. So you voted these. It turns out everything today is a divided report. There aren't 2 amendments for any of these bills. There's one ought to pass as amended report, and either an ought not to pass or an ought to pass, or maybe both on these bills. So I did try to I sent them out ahead of time. I have posted them in the Google Drive in the amendment review, if that's easier for you to look at, but I've also posted them in the the electronic LD file. So hopefully you've had a chance to look at them. I know you've been swamped, but I can walk you through these if you want, or you can look at them and say, yes, I've seen that, I'm okay. If it's a minority report, only the minority members have to approve. If it's a majority report, only the majority members have to approve. The joint rules, the committee rules require you to see an amendment, have a chance to look at it before it gets reported out. It also gives you an opportunity to make changes if it's not what you want, or if you've actually come to an agreement and the whole committee says, well, we could do it this way instead, and we'd all agree. That, I mean, a lot of options here. But this is your last chance in committee, I think.
Yeah, and we don't take a formal vote.
No, you don't need to vote unless, well, there are a couple of them that I'm going to ask you to vote because they were, the report was ought to pass. And in one case, it needs an appropriation section. And so that's an ought to pass as amended report. So you're going to have to, I think you have to re-vote that. And another case, an ought to pass needs a fiscal note. And so that is also an amendment. So that's an ought to pass as amendment.
Okay, thank you. Representative Evangelos is, I don't think he can, oh, great, thank you.
So take as much time as you want. If you don't need me to walk you through it too in too much detail, I won't. I don't want to waste your time, but if you have questions, I'm happy to answer them.
I think committee members, I have a suggestion, which is that we ask Peggy to walk us through one of them initially. We've done a couple of these, but we actually have done very few as a committee. And we'll have to be doing a lot of them and really get used to it over the next couple of weeks. And so if we could have Peggy walk us through one of them kind of in a little bit more detail, and then maybe we can go through the remaining more quickly. Does that sound like a good process, everybody?
Okay. Okay, so part of this kind of assumes that we remember what the bill is, right? We don't always remember the bill. So I'm going to screen share if that's okay. This is going to be LD 366. It's an act regarding emergency guardianship. Come on, there it is. So this should look just like what you got. And this is LD 366. The majority report is ought to pass as amended. And the minority report is ought not to pass. So the only thing that's in the majority report, we knew this at the time, was an appropriation, adding an appropriation for the Health and Human Services, Department of Health and Human Services. So this bill amends the probate code in the appointment of an emergency guardian to define, to say for purposes, for the appointment of an emergency guardian, when it's likely to prevent substantial harm to the adult's physical health, safety, or welfare. So these are folks that are in a hospital and don't need to be in a hospital, and they don't have somebody who can move them from the hospital to another setting. So for purposes of this paragraph, the delay of discharge of a patient in the hospital until the appointment of a guardian constitutes substantial harm. So you can't just have an emergency guardian. The emergency guardian is a step in a guardianship process. But what this is saying is the court could appoint, we're talking about a probate court, appoint an emergency guardian because a patient has been delayed from discharge in the hospital that rises to the level of substantial harm. You can appoint, the court can appoint an emergency guardian, and that emergency guardian can make those decisions. And then later there's a full hearing for appointment of a full guardian. I attached the voting sheet, and this was 1, 2, 3, 4, 5, 6, 7, 8, 9. Yeah, 9 to 5 in favor of the motion. So at the back of this packet, I'm gonna run through real quick. So there's the fiscal note that also has to be attached. And here's the voting sheet. So hopefully that's helpful. Oops, not, just needs to be a little bit smaller. No, still doesn't fit. Anyway, I'll go back to the appropriation. So this appropriation is necessary for the Department of Health and Human Services to do their part in these guardianships, because it's usually the Department of Health and Human Services that is appointed a public guardian when nobody else can step in for somebody that needs a guardian.
Okay, and so you're looking at this point for committee members who voted ought to pass.
Yes.
To weigh in on the amendment.
Right.
Okay, so and I was not among those who voted ought to pass.
You were not, but Representative Harnett was. And
yes, go ahead, Representative Harnett.
Thank you. And I hope this isn't a theme for the day, but I find myself confused again. The ought to pass contains a fiscal note through 4 fiscal years, correct?
Well, the fiscal note, that's explaining that it's not an increasing cost, right? But what you're actually doing is appropriating money for the coming fiscal year and the year after that.
And how is that different than the first page for the fiscal note on the ought not to pass?
Well, there's no fiscal note for ought not to pass. So when we're talking about money on a bill, there are two things. There's an appropriation, which means the legislature has to find the money someplace to give to the department or whoever it is to carry this out. In this case, it's an appropriation of $9,000 a year to DHHS to carry out this bill. The other piece of it is a fiscal note. And very often you have a bill that has a fiscal note, but does not require an appropriation. A lot of bills that create a cause of action identify that the judicial branch understands that there might be some more filing fees. There also might be more judicial time used, but we're not looking at it as something that either will increase revenue, which might need some indication there, but we're not looking for money to be shifted to the judicial branch. So we're not looking for an appropriation. This bill has both. Whenever you have an appropriation or allocation section, you also have to have a fiscal note. But you can have a fiscal note without saying, we're going to spend this much money on this bill.
I guess my question is, why is there a fiscal note on an ought not to pass report?
There's not a fiscal note on the ought not to pass. This is just the majority ought to pass as an amended report.
So page 1 that at the bottom says this amendment is the minority report.
Ah, that's a mistake.
Okay.
Very good. I think perhaps when this was voted in committee, it was the minority that was ought to pass as amended. Thank you very much.
Okay.
See, that's why we have the committee look at this.
So that means I didn't use up one of my I'm confused for the days. Okay.
No, you have them all in store still.
I think he gets an extra one.
Yeah. All right, so for those who, with that change then, for those who voted ought to pass, do you approve of this? And so again, the only change, Peggy, is adding on the fiscal note at the end.
So the amendment itself is the appropriation section, which is on page 1, and the fiscal note, and the correction to the summary.
Thank you.
This is acceptable for me.
And me as well.
Me too.
And let's see if I'm just looking at the representative. Let's see. So representatives Evangelos and Moriarty and Newell and Thorne, if you could also weigh in on whether it's okay.
I apologize, Madam Chair. I'm attempting to multitask. What was the question before us, if you don't mind?
So we just reviewed the ought to pass as amended report. And so we're just asking committee members who voted ought to pass to look at the report and approve it before it leaves our committee.
And this is on 366.
Yep. Representative Moriarty, did you have a question?
Are you asking us to each individually state?
Oh, actually, hand raising is probably a better way to do it. So for those who are on the panel right now and who voted in the majority, if the language review is acceptable to you, please raise your electronic hands. Looks like it is.
All right, thank you.
Okay, so one down.
Yes. So the next one is LD 402, which is an act to protect an individual's personal data. This one, I don't know if this is a little easier. It's a minority ought to pass as amended report, and it replaces the bill. If you remember, we talked about this and had a memo from the CDC about their immunization program, where the rules already authorize somebody to opt out of sharing the information. And so, and you said you'd like to see that, the minority said you'd like to see that in statute. The majority said we're okay with it being in rule. So here's the language from the rule put into statute. So it allows somebody who is receiving immunizations to choose to be excluded from the immunization information system. What that means is they will not be able to go to that system to look for their history of immunizations because the information will not be collected and maintained.
Committee members, it looks like there might be some hands up. Go ahead, Representative Harnett. Okay. Representative Moriarty?
I'm confused, Madam Chair. The vote at the work session on a motion ought not to pass was 5-6, but the final total now is 7-6. So I'm just confused as to what the committee's recommendation ultimately was.
So that's a great question. And so this reflects the fact that committee members, like today, when we took our votes, those who are absent have up to 48 hours to report to the presiding officers, to their presiding officer, what their vote is on a bill. If they missed a work session and were not able to vote at the work session. And so this vote reflects the fact that some votes were cast after the work session, sometime in the next 2 days.
Right, and usually you won't, I mean, the official voting sheet won't look like this. It'll be, filled in by the computer, but you can see here that Senator Sanborn and Representative Harnett, neither of them was at the work session, and they emailed their votes into their presiding officers. Soupy got a copy. She marked them on this, but you can see that I'm pointing at my screen like you can see what I'm pointing at, where it says see attached for Senator Sanborn and Representative Harnett. That's Soupy's noting to herself before she finalizes the voting sheet that she got votes from them, and that's how they voted. So you're right, the X's show who was here on this voting sheet, the X's show who was at the work session. Representative Newell wasn't able to record her vote in time. It's actually noon of the second day that you're supposed to record your vote.
May Soupy correct something?
Go, yes, please.
And I apologize, only because I am not the one that writes see attached.
Oh.
That is done in another office. I just want to make that clear.
Thank you.
The process is different than this year, and your email gets sent to the presiding officer, your respective presiding officer then forwards your email to another office, and then that office then sends it to me with that C attached on it. I'm the one that puts the X in there. Sorry,
No, that's good. I don't know all these things.
Believe me, I don't want to know either. Sorry.
Thank you, Soupy. That was helpful as well. We're all learning. Representative Harnett?
So again, the amendment, the amended version is only of concern for those people that voted ought to pass as amended.
Correct.
They're the only ones who have to do something today.
Right. If you want to change your vote and join them, then, this is the opportunity to do that. But otherwise, it's really for the people who are on that report to decide whether it reflects their report, what they want.
Thank you.
So committee members, if you voted ought to pass as amended on this bill and you are satisfied with the amendment, could you please raise your electronic hand so that we can get a read on whether.
Was that okay to stop sharing, or do you need to know who you are?
No, I think it's good to stop
Okay.
sharing. Okay, it looks like for everybody who is here and who voted ought to pass as amended, their hands are up. So I think we're good with that one.
Okay.
Thanks, everybody.
You want to keep going?
Yeah, I think we should. I think we're all learning new skills, and this is you are a great teacher, Peggy. So let's keep going.
Well, thank you, but we'll see. So the next one is LD 480. This one's a little harder just to look at the amendment. Maybe I will, what I say will remind you of the situation. This is an act to establish a presumption of entitlement to counsel for a person who's a subject of an adult guardianship, conservatorship, or other protective arrangement proceeding. And the bill is intended to kind of flip the presumption. Right now, it's usually a probate judge will appoint counsel when they know that the person doesn't want to have a guardian, or they want to limit the guardian's powers, or there's a concern about the whole process, or the visitor who has gone out to interview the person who is the subject of the guardianship notes that there needs to be some sort of attorney, there needs to be counsel appointed to protect the interests of the adult that's going through this guardianship. The bill says, so the bill reverses the presumption and says you need to appoint a counsel, except when the court finds, the bill says, by clear and convincing evidence that the adult subject to guardianship knowingly and voluntarily refuses such representation and does not wish to contest any aspect of the proceeding or to seek any limitation on the guardian's powers. If they already have an attorney, this doesn't come into play. But if they don't have an attorney and the probate judge is supposed to ask them if the adult clearly says, I don't need an attorney, then an attorney would not be appointed for them. So the bill says clear and convincing. That's a standard that the probate judge would have to find that the person does not need an attorney, has voluntarily refused an attorney. The amendment changes that standard to preponderance of the evidence. So it's a lower standard. So it's easier not to have an attorney appointed, if that makes sense. And so that's the only change that this amendment is doing. It mentions it in 3 places, because the first one is guardianship, the second one is conservatorship, and the third one is other protective proceedings, which is less than a guardianship or conservatorship. It might be for 1 or 2 transactions. And so the majority report is ought to pass as amended with this change from the standard of clear and convincing evidence to preponderance of the evidence that the judge finds the person is waiving their right to counsel.
Well,
Okey-doke.
And there is an additional piece which is really important because it requires money. It requires an appropriation because this is DHHS's estimate of how much it would cost their public guardianship to provide an attorney in the cases that aren't already being provided an attorney. And the fiscal note indicates those costs. So you'll see it. Here's the current coming up biennium, and there's its projected out. It's also determined to be, the fiscal office has said, this looks like it's a state mandate because it's requiring the probate court to appoint attorneys in situations where they are not appointing attorneys. And that is requiring the probate court to incur additional costs because attorneys appointed by a probate judge, those fees don't come out of MCILS, they come out of the county coffers. So this is much more complicated. The language might be easy, the rest of it is a little more complicated.
Thanks, Peggy. And
Want me to stop sharing?
Couple of questions here. Go ahead, Representative Harnett.
Thank you, Madam Chair. And Peggy, to that second point about the mandate, didn't the probate courts pretty much testify they do this anyway, that they're appointing these attorneys in these cases?
Right. I think the testimony was that there's no adult respondent in any of these situations who should have an attorney. The probate courts don't believe there's any adult who should have attorney that is not having an attorney appointed. So I don't know what the problem would be, what those costs would be. Obviously, the Department of Health and Human Services has identified some costs that they think they are not incurring right now with the law as it is.
Thank you.
Representative Moriarty.
Thank you, Madam Chair. Peggy, I'm confused. If it is the counties that are paying for the cost of representation, why are there increased DHHS expenses involved?
Right. So the DHHS expenses would be when the I believe it's when the state is, so if the state is acting as the public guardian or public conservator, then those attorneys' fees costs would actually be on the state rather than the probate court identifying attorneys to take those cases.
Okay. And then just to follow up, do you think that the change in the language regarding burden of proof has any impact upon the projected increased costs?
I do not think that is the driver of these costs.
Right. Okay, thank you.
Committee members, are any additional questions for Peggy about the, well, actually about either aspect of it? The change in the language, is that acceptable to those who voted in favor of this report? And I am one of those who voted in favor of the.
Oh, I'm sorry. Yes, I do have the voting sheet here somewhere.
Yeah.
On the back of the fiscal note.
Right. Just, yeah. It's just too big there.
So the majority report was ought to pass as amended.
Yes, sorry.
And so that's the those of us who have the X's in the leftmost box. And so if we can, when we come out of screen sharing, if this amendment is acceptable to you, please raise your electronic hand. And let me just see if we've got. It looks like we have everybody who was on the majority report who's here has their hand up. So I think that is good, Peggy. Thank you.
All right, thank you. All right, so the next one is LD 535. An act to provide for the well-being of companion animals upon the dissolution of marriage. So this again is a divided report. The majority is ought to pass as amended with 9 votes. Minority report is ought not to pass. Here's what the amendment looks like. And you were really doing some wordsmithing to make sure that a couple of things happened. One was that there would not be joint ownership or joint custody of an animal, that the court would award ownership of the companion animal to only one party after considering the factors. And one of those factors was the well-being and basic daily needs of the companion animal, and struck out financially support and used the broader term of just support, the ability of a party to continue to own, support, and provide adequate care for the companion animal. And what I've done is here's the typical fiscal note that you see. There might be minor cost increase, there might be minor revenue increase from people paying court fees, and might be more suits, probably not, because this is already part of a divorce or separation. And this is where that language goes in the bill, if that's helpful.
That is helpful. Thanks.
So it's easier to read. So although I didn't put all the language there, shall award ownership of the companion animal to only one party after considering all relevant factors, including but not limited to A, the well-being and basic daily needs of the companion animal. And now I'm going to see if I've got the voting sheet here.
And so the yes, the ought to pass as amended votes are in the column on the left. And so Representative Thorne, go ahead.
Thank you, Madam Chair. I was just curious. You said the end vote was 9 in favor.
5, 6, 7, 8, 9. Yes. Does that match with your notes?
I'm just counting it now.
Yeah, it was a mixed bag on the no, and that was why I was just wondering. There was 1, 2, 3, 4, 5, 6, 7, and then Senator Keim, Representative Hagan, and Representative Evangelos were absent at the time of the initial vote. I didn't know who the other 2 that were absent that voted in favor were.
Right. My notes show that Senator Keim, Representative Harnett, and Representative Evangelos were absent at the time of the vote.
Okay.
And four had voted no, and 7 had voted yes. So I think that divides up correctly.
Okay. Thank you.
Yep.
So committee members, if you, are there any other questions, first of all? Okay, so if you voted yes on the ought to pass as amended, please raise your electronic hand if this language is acceptable to you. And it looks like it's acceptable to everyone who voted in favor of it. So that's great. Thank you, Peggy. And I feel like we're developing a little bit of a flow and system
Right.
to doing these language reviews, which is great.
Good. So the next one is LD 563, resolve to create the Criminal Records Committee. This, as I said, is a divided report. It's a majority ought to pass as amended report. I have 9 voting in favor. What were let's see. So the amendment replaces section 2 of the bill, which is the membership. And it actually, although you can't tell because resolves aren't underlined, it actually added 4 people. Let's see. 1 is the Right to Know Advisory Committee chair or the chair's designee. I know that there were press people included. I know they've changed kind of the format of how these are done now. So it's not jumping out at me. But if you remember, the people who testified against this bill were the Maine Press Association. So here's number 18 is a representative of a newspaper and other press interests. 19 is representative of broadcasting interests. And I'm thinking there might be one about.
There's a right to know.
Yeah, 26 is a representative public records access advocacy organization. So the whole idea was this committee is supposed to look at all the laws governing criminal records. You have a whole lot of bills about sealing records or expunging records or saying criminal records of certain types cannot be used for certain purposes. You can't use them in employment context. Let's expunge everything to do with marijuana. The idea is that this group would look at all those records, look at what's going on in other states with regard to expunging records, especially the states where marijuana is no longer a criminal violation, and figure out what to do with those records. And the Maine Press Association and the broadcasting interests were saying, there's a public interest in knowing this information, and we need to be part of that discussion. And so that's why those were amended into the membership of this big group. The core of this group has actually been meeting unofficially for the last 2 or 3 years and working on these issues, but this would make it more official, and it would give you the authority to report out legislation next year that deals with all these issues. Expungement is considered to be unconstitutional in Maine as a separation of powers issue, because only the governor can wipe away that record. So that's one of the things that this group would look at, and how to deal with various types of crimes. I know that there are bills dealing with prostitution and human trafficking, and when those victims of those crimes are pushed into criminal activity and they get convictions, what can you do with those convictions? And so that's one of the things that they'd be looking at.
Peggy, can you take us, I think you've done a great job of focusing on this particular bill. Can you expand us outward a little bit and talk about the chart that you made that summarizes the other bills?
Yes. Except now I have to figure out where it is because I didn't put it up on my screen. Okay, I will do that. So you actually heard one of the bills, which was Representative Fecto's bill about marijuana. Actually talks about convictions and adjudications and taking them out of the State Bureau of Identification. And that's some of the people that would be involved in this group would be the State Bureau of Identification, because they're the ones who are kind of the keepers of the state records.
I think I can find it, Peggy, but I don't think
Here it is. I found it. It's
Here.
just,
Okay.
it wasn't showing up, and that won't work.
I know it's funny how they kind of disappear on us sometimes.
Okay. Close that. Close that. Can you see that?
Yep.
Okay.
Yeah. Will you make it just a little bit bigger?
How's that?
Good.
Bigger?
No, that's great. I think that's good.
Okay. So LD 216 is the bill I was just talking about with Representative Fecto's bill. It would, one of the things this review committee would do would look at how adjudications are taken care of. Those are non-criminal adjudications as opposed to criminal convictions. The SBI tracks criminal convictions. They do not track all the marijuana adjudications for the civil violation of possession of marijuana, which doesn't exist anymore. But there are criminal records, and there are records of adjudications in different places. There are IF&W has their records, Marine Resources has their records, and then there's all the courts records that are there. When you tell the SBI not to do something, not to share this record, it is not necessarily telling anybody else who has a copy of that record not to share it. So that's one of the things this review committee would look at. So I guess maybe I'll stop talking and you can look at all the different bills you have. You've heard 216, you haven't heard any of these others. Do you want me to kind of scroll through?
Sure. Yes, if you could please show us the second page, just so that those who voted ought to pass can take a look, just to refresh ourselves.
Oh, this or the second page of the
No,
resolve?
that's great. Just
Okay.
so that we can look at the titles. And then if you don't mind ending the screen share, Peggy.
I'm happy to do that. Thank you for your patience.
No, that was really helpful. So basically, kind of in a nutshell, for those who voted in favor of the resolve that we're doing the language review on to set up the committee, basically what we'd like to propose, what I'd like to propose is that we let the resolve go forward, have the committee do its work and recommend back to us a comprehensive way to deal with all of the different criminal history records that are touched on by all of these other bills. The thought being that we would vote ought not to pass on all of these other bills, let the study committee or commission do its work and come back with a comprehensive legislative proposal that is covers everything rather than the piecemeal approach that all of these individual bits of legislation take. We would send to that committee a letter from the Judiciary Committee attaching all of these other bills and asking and I forget whether it's a committee or a commission, Peggy, do you mind?
It's a committee, yeah.
Thank you.
Yeah.
I don't want to use the wrong word. And asking that Criminal Records Committee to make sure that in their deliberations on this issue, that they take into account the different policy issues that are addressed and touched on by all of these other bills. We had a little bit of a conversation this morning about carryovers, and this is one way that we can efficiently deal with the situation of not being able to act on each one of these. I think it's 1, 2, 3, 4, seven bills that we can actually create this commission that will come back to us with recommended legislation, and then ought not to pass these other bills in lieu of carrying them over, because this would use up essentially more, a little bit more than almost half of our carryovers. So that's kind of the big picture that we're dealing with here. Go ahead, Representative Harnett.
So in essence, passing one resolve can help us get rid of 7 LDs. Get them
And
off,
yes,
but
and also
have them considered in a responsible fashion.
right, and bring us one unified piece of legislation.
Okay, thank you.
Representative Rackett?
Yes. Am I muted or not muted? I never know.
You're good. We can hear you.
Anyway, I'm just wondering, I have a bill that's being heard next Monday in criminal justice that is as it's written, is an expungement request, but I'm going to change that to sealing the records when the hearing happens next Monday. So would that kind of thing get caught up in 1055? Because it's essentially a decriminalization. There's a piece of the bill that's a decrim.
Well, yeah, I mean, I think that one thing you could do is, regardless of what happens with that particular bill, is that you could have, perhaps even have the Criminal Justice Committee sweep into a letter all of the different legislation that they have that also impacts that issue of sealing or expungement, and do a similar letter like we are doing to this committee.
Yeah. I might ask Charlotte to talk to you, so you're or Tom, so I don't screw it up, but because my brain's a little full right now.
No, I mean, I think it's great
Yeah.
that you have alerted us to the issue, and I'm happy to work with the chairs of criminal justice, because I do think, the unified approach is really what's important here.
Yeah, and I'm certain I'm not the only bill that we did this year that would have those words in it. So I just can't remember which ones they are, but Charlotte would remember probably.
Okay, thank
All
you
right.
for raising that. Representative Moriarty?
Thank you, Madam Chair. So apart from the larger issues that you just discussed, the smaller issue, I guess, embraced within the amendment is the addition of 4 more members to the committee. Am I correct on that?
Yes.
Okay.
And if I could also point out that there is a fiscal note, because this is a study group that would be staffed by legislative council staff, which means probably my office. It goes to the legislative study table, which is, a table that I think it's just before enactment, so it would be in the Senate. And the legislature has a really small budget for studies. And this indicates that it would be $2,750 to do all the printing, mailing, whatever other costs, if there's a public hearing to do some advertising. But those would be the costs that are identified for this study if it's treated as a legislative study. It's not an appropriation. It is an indication to the legislative council when they take up all the studies, this is how much this would cost. And so if they have $10,000 to spend on studies, this will take up a quarter of it.
And so the study might not necessarily get funded.
Correct. What happens is if the House approves and the Senate approves and the House, it's a resolve, so it finally passes the House, it would then sit on the study table until the Legislative Council had an opportunity to review all of them. I mean, it doesn't have to. They could waive it from the table if they thought this was worth going forward and using that amount of legislative funds that have already been appropriated to the legislature to use.
Thank you. Additional questions, committee members?
I just have a correction to make about the chart. The last bill on the chart, LD 1602, is not the same as 1465. It is actually an act regarding criminal records that Representative Talbot Ross sponsored, and it is a concept draft. It is actually exactly like LD 1310, she thought she was going to do some other details and then backed off and said, I'll just do a concept draft because I know this committee is in the works. So yes, it's just like another bill, but we copied the wrong one.
And so, yeah, and actually that raises another important point, which is that one thing we as a committee could do is that we could actually use, we could carry over 1310 in the event that the study committee was not enacted, so that that group could continue to meet less formally, and then we could populate the concept draft 1310 with the recommendations of the committee, even if the resolve that we're addressing now was not enacted and funded. That's a lot of information to put out there. Are there questions? Representative Harnett, you have more expertise in these issues than I do. Is there anything else that we should be discussing on this before we do our show of hands on the language?
I don't think, not that jumps to my mind right now, but as you said, that was a lot of information. But so you're talking about maybe saving, we might have to use one carryover just to have a vehicle in the event this doesn't make it off the legislative funding table or the study table.
Exactly. Yeah, because you can see that, based on the sponsorship and the types of bills, that this really is a pressing issue that needs to be addressed, and we want to make sure that we don't lose the opportunity to address it.
Makes sense.
So right now we're just working with the study committee and the language review on that. And so let's take a step back from the big picture and just look at the additions to the study committee. And for those who voted in favor of the legislation creating the study committee, if you could please raise your electronic hands if the language is acceptable to you. And I just want to take a quick peek at the vote. Let's see, and it looks like it's acceptable to everybody who voted on this report. So that's great. So another one completed.
Great. So the next one is LD 579. This is also a resolve, and it is resolved to conduct an independent examination of the protection order system to determine whether there is systemic misuse by applicants. And 579, the minority report is ought to pass as amended, and I'm going to share my screen. If you remember, this directs the Maine Commission on Domestic and Sexual Abuse to do a study, and they indicated that they can't do the study on their own. They would have to contract that out, and the fiscal office identified costs of $50,000 for them to do the study as identified in the resolve. And so this is an appropriation of $50,000 that would go to the Department of Public Safety for the Domestic Abuse Commission to contract out that study. So this amendment, it doesn't change the text of the bill. It adds the appropriation, and then it also needs to add the fiscal note. And this is where the projections are important. It shows it's a one-time cost. And then this is the divided report voting sheet. So I think we're still, Representative Hagan was not able to add his vote. So this is one where the motion was ought to pass. And no, the motion was ought not to pass. And that passed, but the those not voting in favor of the ought not to pass said we want ought to pass. And so that's how we've indicated it. And that's how, if anybody was responding, was saying ought to pass. Supi and I have talked about this, and the records show that it was an ought to pass as opposed to an ought to pass as amended. So we think you need to re-vote this in order to turn that ought to pass motion into an ought to pass as amended to include the appropriation and the fiscal note. And I'm sorry to make you go through that.
That's okay. So Representatives Libby and Thorne, you're the folks most impacted by the ought to pass vote, and is the addition of the fiscal note acceptable to you?
I'm going to stop sharing.
Okay. Yes, Representative Libby?
Given the fiscal note, we are going to have a revote, correct?
Yes.
I will likely change my vote on a revote.
Okay.
But the fiscal note looks fine.
Okay.
And if we are bringing it up again, I probably will change my vote.
Okay. Representative Thorne, do you accept the fiscal note?
Yes.
As part of your report? Okay. And so at this point it would be, so we need to move to reconsider. Is that correct, Peggy?
I believe so. And here's one of those odd things where it's because you all work together as a great committee, the people who the prevailing side was ought not to pass. So somebody on the prevailing side, I believe, is supposed to move to reconsider so you can revote this.
Okay, Representative Evangelos, did you raise your hand to do that? Representative Evangelos, I don't know if you're speaking, but we
move to reconsider. I have my mic off. Yes, Madam Chair, move to reconsider. Sorry.
And seconded by Representative Harnett. So we're moving to reconsider. And so all of those in favor of reconsideration, so this isn't the vote on the bill, this is the vote on reconsideration, just raise your electronic hands if you're in favor of a reconsideration.
Could you restate the LD number, please?
579.
Thank you.
So looks like the motion to reconsider is unanimous. Vote, go ahead.
No, I'm sorry. In talking, am I on mute?
We hear you.
Okay, I'm sorry. In talking to other committee clerks, and we discuss what gets called and what doesn't, reconsider, most people call the roll. So I don't want to slow things down, but that's more than just a table.
Let's call the roll then, please. Thank you so much for bringing that up.
I'll go fast. Representative Carney.
Yes.
Representative Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
I apologize. This is an ought not to pass motion, correct?
This is a reconsider.
This is still the reconsider. Okay, I got confused with the electronic hands. Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentee. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 10 members voting in the affirmative and 0 in the negative, and 4 members are absent.
Thank you so much, Ms. Panett. So the reconsideration motion carries 10 to 0 to 4. And so now we will move on to revoting on LD and we're going to revote on the LD, but Supi, could you please give me the LD number again? I'm sorry.
Yes, LD 579.
Okay, thank you. Representative Libby, you had your hand raised?
Yes, I apologize, Madam Chair. I do need to request a corner caucus. I literally need 2 minutes.
Okay, that's fine.
Anne,
Yes.
I left a message for Charlotte that you might be in contact, or she might want to be in contact with you about the criminal records issue.
Terrific. Thank you. And I'm thanks for spotting that issue for us.
I have to say it is useful to have one person who sits on both committees. You
Mhm.
just should get a gold star at the end. Honest to God. Or some when the goodies start rolling into judiciary, I'm going to take more than my share if it's gluten-free. I'm just saying. Oh. By the way, I won't be disappearing because the lunch hour was so generous that I went and executed the document I had to execute it.
Oh, good.
Representative Galgay Reckitt.
Yep.
I have to say, and I feel horrible about this, but I went shopping the other day and the prices of bakery items or baked goods, to cook is unbelievably high.
Isn't
And
it?
I started to
Yeah.
think, I don't know if I'm going to be baking next year for you all because I don't know if I can afford,
Yeah.
chocolate chips the other day was like $5 for a little bag.
Oh my
Point of
God.
order.
I'm
Point
sorry?
of order, Soupy.
Uh-oh, I knew
You're not
it.
getting away with that one.
I was hoping you weren't there.
Well,
I'm sorry.
You could charge us more.
Yeah.
I'll be
Well, we
honest, if we're still on Zoom, there's no cooking. I haven't cooked forever.
I'll pay you more, Soupy.
Oh, you'll give me more? Okay.
I've heard a lot about these treats, so.
Well, I did just print a recipe for a chocolate brownie pie.
Oh,
That's why there's a waiting list to get on judiciary.
I'm still looking for recipes. I know I'll change my mind next year once you're all back. I'll be so happy to have you all back in the room and being able to feed you. And
I can't wait.
this has just been a hard session.
Yeah. The thing I've taken to asking for my birthday, it's called an angel pie that my cousin gave us the recipe for. The crust is crushed something, macadamia nuts. It's crushed something, and the inside is filled with a combination of chocolate and it's like whipped chocolate. It's like sort of Anyway, I'll try to get the recipe from my wife, who's the one that makes it, because I don't cook. But it's just to die for. This pie might not work for judiciary because it has to be refrigerated.
Oh, we have refrigerators.
Yeah, and for that we might.
I
So,
brought my mentor a tart just for being so helpful, and actually brought it in a little cooler with ice in it. So don't hesitate to bring it just because it needs to be refrigerated, Lois. I can help with that.
The other thing I miss this year is that usually, because St. Patrick's Day has been screwed up for 2 years now, and my wife usually makes me a gluten-free Irish soda bread, which I just love. So, but we've both been so blessed busy. She's working on in the other end of the house in the kitchen because her office is being renovated, and I'm here in this end of the house listening to the hammering in her office, which is the next door. Except the contractor's not here, but.
All right, everybody. It looks like we're all back. And so we have the motion to reconsider has passed. And now we're moving on to revote LD 579. And is there a committee member who would like to make a motion? Representative Harnett?
Motion ought not to pass.
And is there a second?
Second.
Seconded by Representative Poirier. And Supi, I think we're out. Any discussion? Not seeing any. I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yeah.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent.
Thank you very much, Ms. Panett. And so the ought not to pass vote carries. And that closes our reconsideration on LD 579.
All right, just a couple more. The next one is LD 622. This is an act to prohibit marriage of any person under 18 years of age. This report was actually divided 3 ways. The majority report is ought to pass, and no fiscal note is required. That's 9 people. 4 people voted ought not to pass. And then 1 person, Representative Evangelos, voted ought to pass as amended. And that's what this amendment is. It changes it to prohibit marriage of any person under 17 years of age, trying to tie it to when you need parental consent to sign up for the military, enlist in the military. So this is Representative Evangelos's amendment. And so it changes it, instead of current law is 16, the bill changed it to 18. This amendment changes it to 17. And I'm gonna scroll and show you what I have for the voting sheet. make this smaller so you can see it all. Are we all set?
I think so. Representative Evangelos, is that amendment acceptable to you?
Yes, I actually remember discussing it with everything else that's in our heads. But I do, you know, it's not my top priority issue of the year, but obviously I just thought, I felt bad. You know, you got to do the military thing, but you can't get married. Sounds a little silly to me. So, especially if you're going away and you've got a spouse, man or woman, that you're close to, you might want to tie the knot before you head for Iraq or something. So you know, it just, that was in my mind. Yes, it's perfect.
Thank you.
Perfect. Okay. Thank you. Last one I think I have, well, the last one I have for you to look at is 719, which is the resolve to establish a commission to create a plan to incorporate the probate courts into the judicial branch. This is the majority report, and all it does is add the fiscal note, and this is another one where the majority voted ought to pass, and it has to be amended to add the fiscal note. This is the fiscal note. It's also a legislative study, so it's the same thing that the Criminal Records Committee is looking at. But that was incorporated into the amendment. This is a brand new amendment because there weren't any other changes to the resolve. And then I will show you the voting sheet. So the motion was ought to pass.
So we have to reconsider again?
Yes, I think you do. That would be, unfortunately, the way to keep the record straight.
Mm-hmm.
Unfortunately, that means the people who are not here will have to vote again. You know, go through this process where they will have to notify the presiding officers of their votes.
Okie doke. So, so the first order of business would be a motion to reconsider by someone who was on the prevailing side. Is that correct, Peggy?
That's my understanding, yes.
Yeah.
Okay.
I
And-
move to reconsider.
Thank you. And is there a second?
Second.
Okay, so
Oh,
motion.
wait, I wasn't on the prevailing side.
Oh, okay. So is there a motion to
Your vote
reconsider?
wasn't even recorded,
Yeah,
Representative.
really? How did that happen?
Well, here you go. We can get everybody on board this time.
Yeah, I could have sworn I had voted on everything, but apparently not.
So Representative Moriarty is making the motion to reconsider.
Yes.
And who is going to second it? Like Representative Sheehan has seconded it. And so Supi, if you could please call the roll on the motion to reconsider. Representative Harnett, did you have a question?
I do, Madam Chair. If you're listed as not having voted, which I don't know why I am listed that way, but I am, are you still allowed to vote on the motion to reconsider?
I think everybody can vote on the motion to
Okay.
reconsider.
Thank you.
I'm not the parliamentarian, but
For Representative Harnett, you did vote. You just weren't there the day of the vote. You see, it says see attached.
Okay.
So you actually did vote.
Okay, then
Susan
I
just
have,
didn't put her X's in.
I have no moral qualms then. We can go ahead.
Okay. I hadn't had a chance to look at it, so I apologize. Ready for the reconsider vote?
Yes.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
No. Oh, this is reconsider, right?
This is to reconsider.
Oh, yes, sorry.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent.
Thank you very much. So the reconsideration on 719 passes. And then is there a, would a committee member like to make a motion? Representative Reckitt, do you want to make a motion?
Sure. I'd like to, am I unmuted?
Yes.
I'd like to move ought to pass as amended.
Thank you. And is there a second?
I'll second.
Seconded by Representative Moriarty. Any discussion? Nope, I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
I apologize, you guys. I am lost what bill number we're on. This is 719,
Yes.
Correct.
and this is ought to pass
As amended.
as amended. No. Thank you.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I can see.
Yes.
Representative Newell votes yes. I will call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 7 members voting in the affirmative, 3 members in the negative, and 4 members are absent.
Thank you. And for those who voted in the negative, is your report ought not to pass?
Correct.
Thank you very much. And so the ought to pass as amended carries 7-3 with 4 absences. And we'll close the work session on 719 or the reconsideration on 719. Peggy, I'll turn it back over to you.
Well, thank you. I only have one more thing, and it was I had a conversation with Senator Keim yesterday about LD 725, but she's not here, and I don't want to speak out of turn. So she said I could bring it up, and if members, so that's a divided report. LD 725 is Representative Dillingham's bill about publicizing complaints that are made to state agencies, basically. And Senator Keim said that folks had been talking about it and there might be a change, and she said I should bring it up, but not push it. So I brought it up.
Okay, is there any interest in reconsidering 725, or is this something that we simply want to wait until Senator Keim can join us and speak about it a little more in depth?
Madam Chair, without getting too much into it, what was the amendment?
I had drafted an amendment. I did not send it out. I had drafted an amendment and sent it to the folks on the ought not to pass report. or at least I sent it to Senator Kime. And she said that you had had a discussion about whether or not to go forward with the bill. And I'm really reluctant to speak more about it without Senator Kime here.
As I understand it, the motion was ought not to pass that carried. And the minority report was ought to pass as amended.
Yes.
And that was on the minority report.
Right.
Aspect.
So, yes, and I was trying to draft an amendment for the minority on that.
Yeah, then I'm in concurrence with you. We'll wait till Senator comes around.
Representative Libby?
Yes, I agree with Representative Thorne. We have had ongoing conversations about this bill, but we're not at a place to present as amended. It seems like things are still coming to light regarding the circumstances that initiated this bill.
All right.
Thank you.
Yeah.
Peggy?
Thanks for bringing it up.
Could I ask Peggy a question?
Yes.
So what you heard us discussing the fact of the crossover around judiciary and criminal justice on the criminal records piece.
Yes.
I have a printout copy of what you sent us, but it was mixed in with a bunch of, I think maybe all the work session. I mean, all the amendment
All
reviews.
the amendments, right?
And I don't have it anymore because I erased it because I erased things, you know. So can you send that particular piece to Charlotte and Tom Hartnett?
I will do that, except I'll correct it first.
Okay, that'd be fine. But anyway, I sent them a note to, not you, Tom, Charlotte, and
Senator Deschambault.
Deschambault, thank you.
And I will copy Jane. So
yeah,
yes,
thank you.
Yes.
They're expecting to hear from somebody, so that would be a
okay. I'll take care of that.
All right, thanks so much.
Thank you. And I think that we have covered everything that we can cover today, I believe. Made great use of this afternoon, and everybody was very great at just leaning in and getting the work done in a really efficient way. So Soupy has her hand raised. And you're muted, Soupy.
My apologies. Do you mind if I talk about just a couple of things, procedural things? One of them is, after this work session, I send you the vote sheets to the people that miss votes. And all I'm asking is if you could send that back as soon as possible so all your votes get recorded. So you notice some people weren't on there. You're doing great, but this is kind of an odd way of doing it, but that's what they want. So all I'm asking is just look out for that. I will send it the same night that we have the work session. Like today, it'll go out tonight. The only other thing I need to mention, and this is for the people on the first floor, on all divided reports, normally what I would do is I would go around with the jacket and I would get your signatures. That obviously can't be done this year. So it all has to be done electronically. So you may have noticed you've been getting some emails from somebody named Casey Milligan or somebody from the Legislative Info Office, and they're asking you to send back an email saying that you agree with that particular vote. Until you send that email back, they will not report the bill out. So Judiciary has quite a few divided reports sitting on her desk. So all I ask is if you get that email, I think she sent out reminders this morning, perhaps. If you get that email, would you please turn that around as quickly as you possibly can and get that back to her? Because otherwise, all this talk about these divided reports that we have, they're not going anywhere.
Yeah.
Okay, because she has to get back 14 emails.
And Soupy, just to clarify, when people send back the vote sheets, they're actually sending it to their presiding officer and rather than to you, right?
On the vote, on the vote that you missed in committee. But for that email, for that agreement on how you voted, I believe that needs to go back to the Legislative Info Office.
Yeah, exactly. So two different, the first vote goes to presiding officers.
Correct.
The second goes back to Leo,
Correct.
to Casey Milligan.
Oh, I like that, Leo. Okay.
Yeah.
I'll fall on the sword on that one. I was under the assumption, I wasn't aware that she needed confirmation from everyone on the minority report. I was under the assumption that just the lead on the minority report, she needed confirmation on. So I'll have to go back and look at those because I already saw a response. So I never answered because I saw that there was a response and I thought it was just the lead that they needed the response from, not every member.
Believe me, you're not the only one. This is extremely confusing for a lot of people. There are some, she was saying the other day in our meeting that there were some that she was been waiting for 3 weeks. So don't feel bad. You're doing good.
Thanks, Soupy.
You're welcome. Thank you.
Any other advice or directions for us?
Not for me.
Okay, a couple of hands up. Representative Evangelos, you were next.
Thank you, Madam Chair. I wanted to thank Peggy today for a great job. You made it easy, and that stuff can be hard. So thank you very much. On the voting, one thing I do, I get up in the morning, get on those emails. The minute I see it, I vote, and then it doesn't get lost. I send mine to Jane and Lynn. This is for the House members. They take care of the rest. I copy Soupy every time. And then I see tomorrow we're going to have a like Friday, huh? Friday day tomorrow. It's going to be like Friday, 12:30, 1 o'clock. What do you think? We get bogged down in even one of those. We are.
Yeah, I mean, you raise a great point, Representative Evangelos, is that we have work sessions on, I'm not going to count them, but like 15 bills. And so that's a lot to prepare for. It's a good thing we're getting out a little early today, but the work sessions will go more quickly if we have a little time, which we do today, to refresh ourselves in advance of those.
We're doing our best under difficult circumstances. Thank you.
Yeah, everybody's doing amazing work for sure. Representative Harnett?
Yes, and thank you, Madam Chair, and I'm not going to lengthen the day. Soupy, two things about the emails from Casey Milligan. One, she is asking for us to confirm our individual vote, correct? Not that the entire slate is correct.
Your individual vote, correct.
Okay, and the other is a tip. She says it in the email, do not reply all, because then we're all getting your confirmations. So I know sometimes we default to reply all. I think we all can agree. We might not agree on everything, but I think we could unanimously vote that we get too many emails.
Yes.
Thank you.
Peggy?
I don't want to prolong things either. Two things. Tomorrow, your first bill, we have ASL interpreters. And so that will be a new experience for me doing it on Zoom. I know that we've had interpreters in the past. So that'll be the first bill tomorrow. And then for the afternoon in the work session, you have several bills on remote participation. I'm instead of doing an individual bill analysis for each one, I'm putting a chart together with kind of a cover memo and some background, and I'm hoping that will help you work through them kind of simultaneously rather than individually. I think the Cultural Affairs Council bill is a little bit different, but I'm talking about 3268, 746, and 1578, although I think Senator Sanborn is going to take a not to pass on that. But I mean, it's a big issue, and I'm really hoping you can work through it in a logical manner. And I'm hoping what I'm putting together for you will be useful. And I will be sending I already sent the bill analyses, didn't I? I posted them. Yeah, I sent them. Okay, good.
And Peggy, I think that the cultural affairs may be covered by one of the other bills. Even though it is different, it may end up being unnecessary.
Well, I will tell you that in the past, the legislature has not been a fan of remote participation bills. And although it did pass for the pandemic, so you may want to keep that bill in case the others don't pass.
Thank you. That's a good point. Anything else, committee members? All right. See you all tomorrow morning at 10 a.m. for another busy day. Thank you all.
Sounds good. Take care, all.
Take care.
Yes, thank you. This was great.
Yeah.
Feels weird to leave now. It feels like, God, it's 20 past 3. What am I going to do for the rest of the day? Probably read more bill analyses.
This time I might get them read before the.
Take care, everybody.
All right. Good night now.